Yes. Item number 1.
Yeah, for the reconstruction matter. I have the entire copy. I have lotion. There's 2 sets of copy, including order copy and application. Mama display. Mama says, Mama says.
তোমার কাছে ডিসপোজ হয়ে গেছে
না ইমাম না এটা 1 নম্বর। হ্যাঁ ইমাম ডিসপ্লে কোড ফাইল খুঁজে পাচ্ছে না, সেই জন্য রিকনস্ট্রাকশন করছে। ইমাম 21 সালে ডিসপোজ করে গেছে।
It has already been disposed of.
Lordship,
But another application for review is pending another detail.
Another application for?
review. There is
So for facilitating hearing of the review, you want reconstruction.
there is a 4 matter analogous matter. 3 matter has been pending before the review application, and 1 is filed.
3 are pending before?
1 matter is prefer an review application before Justice Boshal. Lordship.
So how it can come before different benches?
That's
No,
the
no.
difficulty. But
No, this is WPST matter, Lordship. Until-
3 decisions have been disposed of
Huh.
by Justice Cadre. 1 review application was filed, rejected. Then 1 party filed the SLP. Now it is still pending.
SLP is pending.
SLP is pending.
But another review application filed.
That is pending.
That
for the
is,
decision. And this is a third
Then
petition.
why it is coming before us? If 2
Lordship,
reviews have been
I'll file the review application, but without certificate, I could not file the review
No,
application.
but then it should be considered by the bench where the review is being
No.
considered.
I mentioned without original certificate, they have not filed. I have not filed before the ban.
We are understanding your difficulty. Your difficulty is that because the original record is not traceable, there will be a problem in filing and consideration. But if the review is being considered by a bench, has been and is being considered by another bench. So without the record, that bench is considering that without the records.
No, this is another matter, Lordship.
No, but they are all arising out of a common order.
Common order, Lordship.
So there, how can different benches consider it?
Lordship, I'm praying for only certified copy.
No. Then you mentioned before that bench.
What is pending before this bench?
Nothing.
Nothing is pending.
So,
No, Lordship,
Why should we pass any order?
because without certified copy, I could not file a similar review application.
Therefore, we are asking you any difficulty which arises, has this been given the determination to deal with all these things?
Lordship, because without reconstruction, I could not.
You have to mention before the appropriate bench where the
This
review.
order has been passed 2021. There's a 3 years
We are
delay.
asking you
Huh.
when the orders, when where there is a composite order and different parties are assailing it, one bench has considered it. Can any other bench consider it?
No, that is not the same party, Lordship. Parties are different.
That's why we are saying there is a composite order. Several parties are challenging the order because they are affected by the same order.
Huh.
Should different benches consider it?
No, but I have mentioned before this court, without certificate copy, without memo number, I could not tag together the review application. So you filed another separate review
So
application.
therefore, your difficulty is before that court. You should mention before that court that how I can file a memo unless the file is reconstructed.
But file is original determination before your lordship. This is WPS.
Never told us. We didn't know this today. Mr. Mukherjee is informing us. Every day you are saying we want file reconstruction. We thought it is arising out of tribunal matter. We have to
I went that court.
It is there
Lordship.
today. What is the serial number?
serial number
43. Dekhana. Shukriya. Please show.
matter 43. This is also.
Oh yes, Sri Sandhu Bose. So RBW 31 of 20.
That is WPS.
Well, cannot be not put. The nothing is pending. That is signed.
Even I'm paying for leave for filing review application. This is that problem. And court order me without certificate.
It is already assigned.
It is already assigned.
That matter is already assigned. It is an assigned matter. Then how we can do it, madam? We cannot. You should have told us that another review is pending from this. It is not another matter. You, that we know, you have told us sufficient number of times, but they are all challenging the same order. How a different bench can consider? What should we do? Yes, take down. The matter was mentioned. Everything.
It was done before you have the determination in WPST. Therefore, he
No, we have understood why you have come here, but now we should not proceed when it is being considered by another.
matter has been disposed of in the year 2021, but without certificate, how
How
can
that is relevant? How that is relevant? Yes. The point is whether we are to consider or not. That is all. Yes.
Blood, may I intervene, blood? Blood is permits, blood.
Yes, please.
Blood, all that we require is a copy of the blood order, blood.
All right. We have passed the order, sir. Yes. Next.
The blood.
Item number 2,
This is the review recall.
recalling or order passed by your lordship, and that should be hard fast in your lordship already recorded.
That is in WPST.
WPST, my lord, 204.
Yes, give that file. No, no. Recall is in which case?
In respect of 204.
So give the file.
2240.
24. You are the applicant.
Yes.
On what ground you are seeking a recall or review? Such as?
of temporary law rate has given awarded pensions of temporary be awarded. But some part of the service career was the master role and master role is not included in
So practically you want to re-argue the matter. That is not the scope of a review. So where is your application? What is the application number?
What?
That is wonderful. Yes,
Order, it is, uh, 30%.
yes,
The second paragraph was made a permanent via their 1981 not systematic temporary phenomenon at the outset after. So when he is, because at that point of time when this judgment, my judgment was made, we were not having instruction that we were after all, then that period of time, from temporary service till the date of his absorption, Lordship has taken that point. But the muster one point that somehow inadvertently that was not placed before the Lordship. This is what I'm trying to indicate. I have some relevant paragraphs. If you allow me to place, this is my canvas.
yes,
Paragraph number 2, page number 7. See,
Come to paragraph 8 of your application. That seems to be your case, 8 and 9. Yes.
Employee and not a temporary employee. Service is a master role employee is of a daily wage wager and under certain principles of labor law does not qualify as service for the purposes of pension benefits under the DPRD.
Yes.
That in terms paragraph 9. That in terms of the provision of 1 of the best service. Death come retirement benefit to society. In order to count past service, a worker's past service must be either temporary or officially. Here, I just want to only say that master role. It is in no way applicable for a master role worker like late Shitish Daskar, husband of the petitioner number 1, Vishal Daskar. Then paragraph number 10, and all the necessary documents as well. That there
Yes, yes.
that there is competition for employees and temporary employees with respect to benefits provided in the PWD code volume 1, 360 of PWD code volume 1, which reads as follows. Payment on master rolls should be made as expeditiously as each payment should be made by the highest standard available. Who should certify the payment provided by a distributed mark is each of the amount paid on each payment should be reimbursed as well as the payment of the master. 2. Payments on master roll should, however, be confined to paid workers, paid laborers only, and should never be extended to the permanent and temporary employees whose pay is charged to the head establishment or to the members of the work charge establishment. That as recently as May 2024, accordingly, when of the Honorable High Court in Satish Chatterjee versus West Bengal Election Control Board, 2024 SCP online Calcutta 393 Calcutta High Court reiterated the distinction between work charge employees and master role employees as follows. Work charge employees are normally engaged on a work charge employees normally engaged on a temporary basis for the execution of specified work and their service is contributed to the execution of the specific work. They do not get any benefit under the Payment Gratuity, etc. Act. However, they are in a better position to service servants who are liable to be put out of employment without any kind of compensatory benefits. See just 1 6% paragraph this 26. The master employees are daily rated payment of master roles.
No, the point is how they are different from the petitioners before the court in Nimaichand Chatterjee. We don't want to see what are the ingredients of a muster rule. What is the distinction between these petitioners and petitioners in Nimaichand Chatterjee?
Chatterjee, your lordship, where that judgment was placed, temporary service.
What they were working as?
Initially, master role. Initially, when he was in 1981.
They were working as seasonal beldars. And thereafter their status changed. When?
That it was from 2004.
They changed. No, in 2004, what did they become? You prepare yourself. You prepare yourself. The learned advocate for the applicant. We'll see.
I am not disclosing my.
Their main thing that they are trying to harp upon is that they did not file an opposition.
Was there.
in the tribunal. In only such cases, I don't allow because that has to be confined to the tribunal's records.
There, reading here, calling
So is the reply filed before the tribunal on record?
annexed.
All right. Very well. We'll see. Be
Lordship,
prepared with the dates and see what is the distinction between the two. That is all. We are not see what is the ingredients of a muster roll, what is the ingredients of a work charge, and what is the ingredients of a temporary. That's not the issue. The issue is, can you distinguish these petitioners with that who were before the court in Nimai Chand Chatterjee? That's all. Yes.
And following Nimaicha, the Lordship also decided another matter.
Let's see.
The pros are
No,
like-
they are saying these are not work charge. They are on muster roll.
Yes, same.
Yes.
Honorable- your
Let's
Lordship,
see.
And honorable bench held daily wager slash casual seasonal slash up to
So-
Supreme Court up.
We'll see.
And definition of temporary, they do not.
We'll see.
Since I have come up before your lordships with this CAN application, so I will definitely come up with list of dates and my own.
And one thing, my lord, I shall be conveying, since it is a recalling application, distinct from the review. My lord, kindly remember it. My lord, in terms of the appellate side chapter,
ঠিক আছে।
it is not the review. Review means your lordship can go through. And recalling, 4 points are there. Honorable Supreme Court decided. I shall.
Lordship, what has fallen from your lordship? Whether in 2004, what his status has.
No. We are not circumscribing you by any observation. You are free to argue whatever. But we are saying you need not go into the ingredients of a muster roll and work charge. The first thing is how they are to be distinguished from the petitioners before the court in Nimai Chand Chatterjee. That's all. And that is the only issue. Yes.
Can it be on Wednesday itself?
Can be. Yes. Instead of Monday, give date of first.
Which is the next
Huh?
week, or next week. Not tomorrow. Much obliged, still. Grateful.
Item number 5.
Item number 5, Lordship, my application.
5.
Yes. This is an assigned matter. Yes, what is it?
Lordship, here the respondent husband died in harness while working as a primary teacher under the district primary school council Purulia.
Under the
Under the district primary school council Purulia.
Purulia.
Lordship. On such there happened, Lordship, would expected from the certificate issued by the Gram Pradhan and due to all approval of service completed 1 year, 26 days before he has died. And they are claiming the family pension. That circular is annexed to Lordship, page 59. Page 59, Lordship. Paragraph 4. Since the exception of pensionary benefit to the employees or their widows to the above categories was under the active consideration of the state government for some time past. After consideration the fact as a social security measures, the governor has been pleased to extend pensionary benefit under DCRB scheme 1981 to such widow of those employees who retired died in harness prior to 1981. If concerned employees rendered at least 1 year's approval of the qualifying service in the West Bengal non-government aided education institution. Report also contempt application that was stayed by the division bench. Honorable division bench lordship.
Yes, what is wrong with the order?
Lordship, only 26 days delay memo has been stayed to 12 July 2011. 26 days, 1 year has not been completed, Lordship. For that reason, state has preferred an appeal before you know.
No, not for that reason. You have preferred an appeal because the writ court has allowed the condonation.
Yes.
So what is wrong in allowing the condonation of 26 days? Why it should not be? Tell us.
There is an government memo, Lordship,
Please tell us. Argue your
Yes.
case.
page 59, Lordship. Page 59, paragraph,
Page
page 59.
of
Page 58, it has been started.
of the paper. Yes, page 59.
Page 59, paragraph 4, Lordship. Here has been stated that rendered at least 1 year approval qualification service in national non-government aided educational institution. Para 4, line 5.
That is not in dispute. Who is disputing that 1 year is required? And who is disputing that there was a deficiency of 26 days? Even they will not dispute this fact. This is an admitted position.
Target also be open, Lordship.
Huh?
Target also be open. Everyone,
Can you please speak in the mic?
Lordship, floodgate can be opened. That one has been allowed. Then everybody will come.
RTI can be obtained. See, what is your submission? I'm sorry, we are not able to understand.
My submission.
May I assist your lordship? My learned friend is saying if this appeal is not allowed, a floodgate will be opened.
Oh.
That has been taken care of in the decisions which I will cite.
So that is your only concern.
My lord, I came before this honorable court on a previous occasion, which is at page 24. 8th of May 2014. This honorable court says, extend the benefit of the pension.
There was a positive direction.
Positive direction. Then my lord kindly turns to page 25. After this direction is passed, my claim is negated on the ground of deficiency of 26 days. I assail it in the second writ petition before the honorable single judge, and my lord, 3 decisions are cited in the judgment under appeal. I'll show those decisions, my lord. page 30 to 36.
Yes, that is the judgment of His Lordship Justice Chakravarti.
Yes.
Yes, we have gone through it.
And there's also a division bench which has taken care of this floodgate argument. My lord, I have brought that.
No, if there is a similar set of facts, then they will have to.
Yes, my lord. This is 2012 SCC Online Cal 9059. This corresponds with 2013 1CH and 438, which has been relied upon in page 32. দুটো করে কপি দিয়েছো? My lord, please turn to the third page of this judgment. The rejection order for entitlement of pension was negated by the authority. In the middle, my lord, it starts with the expression with reference to your letter dated. Lordship has that, my lord?
Just a minute. Page, second page.
Yes, my lord, second page in the middle. Sorry, the third page in the middle. It starts with, sir, with reference to your letter dated 29/2002. My lord has got it, my lord. Then, my lord, please turn to the next page. The third paragraph from the top. Undisputedly, the government of West Bengal refused to condone only 13 days deficiency. In my case, it is 26 days. Then, my lord, in the middle, something on floodgate argument in bold.
And where is this memo of 12 July 2011?
My lord, I am showing it. Page. No, it is not in page 58. It is at page 61. 12 July 2011. Lord, the judgment under appeal, which is at page 30, is dated on 28th of June 2016. The direction says, my pension is to be disbursed within 8 weeks. That takes us to the 23rd of August 2016 from the date of the order. And we are in 2025. Lord, I am yet to receive the pension.
So why this memo has been referred at page 24?
24. Because, my lord, initially, when the pension scheme was introduced on May 15, 1985, this benefit was not extended to the widows. 12 July 2011, this extension happened. For cases who have died for
There is a living spouse of the deceased.
living spouse. My lord, those are my submissions.
Third learned advocate for the
Item number 9. Oh, 6. Item number 6.
My lord, the Mr. India citizen of India and appointed as a head constable in 25th May 1969. Some occurrence happened in 1972. The department issued a suspension order. I challenge the impugned order of suspension order.
Lordship,
After this, the department issued the dismissal order.
Lordship, Mrs. Chandrayalam is appearing on behalf of the respondent. She is engaged in code number 23.
Challenge
Praying
the
for short pass over.
My lord, I challenge the impugned order of dismissal order in Honorable High Court at Calcutta. On that period, Honorable
She is engaged in code number 23. Praying for short pass over.
শর্ট পাস ওভার করছে ম্যাডাম, একটু আটকে আছে অন্য কোর্টে, আসছেন আসলে মামলাটা ধরবে 5 মিনিট ওয়েট করুন। অর্ডার দিচ্ছে ওয়েট করলে প্লিজ উঠবে কোর্ট পাস হবে।
So, my lord, 25th May 1972, the department issued the dismissal order, and I challenge the impugned order of Honorable High Court at Calcutta.
Lordship,
That period,
Lordship, the compilation that I filed, Lordship comes to page 67. 67 onwards is other orders as stated. I mean, they've given more that was required, Lordship.
60
7 of the compilation. That starts with WP 915 of 1999.
serial 38
Lordship.
of the compilation.
Page 67 of the compilation.
Just see the index. See the index, perhaps it is serial 38. The leftmost column. WP number 915W.
WP number 915.
Yes, there is a serial number on the left column.
Yes.
So 38.
30. Yes. So from there, Lordship, as your Lordship said, directed, it actually starts from this point.
Problem is, how do we communicate with him? He is not able to.
But Lordship, now that the entire records are before your Lordships can, I mean, come to a finding because
This has been filed against which order?
it has been filed against the orders passed in the contempt, Lordship. That is, it's been filed against. First order is order dated 2019, Lordship, at page 106.
This appeal, just a minute, where is the memorandum?
13 September 2019, page 106 of the compilation.
I know the challenge the impugned order of premature retirement contracts. When I was posted at Manipur
Challenge
or Achanpur,
I'm looking for the memorandum. We see what his challenge is. Go through the records for nothing. So delay and everything has been condoned.
Lordship, delay, I mean, he had given the date of delay, Lordship, those defects has not been cured because the stamp reporter had, I don't know how many days delay he's given because
32 days,
30, 32,
32 days.
32 days, Lordship. He filed an application which was not, I mean, tallying with something else had come into the application. Just 32 days, I think Lordship will condone the delay and proceed. I think that will be instead of.
We have got it. The point is how to deal with the other thing. There's no condemnation. This one. Why not? He's suffering with disability.
He has filed a supplementary to the application for condonation of delay. Therefore, Lordship, I think.
Which is the application for condonation?
Lordship, that is the can marking is not with me. In this application was affirmed.
No, what is the can number?
Can number is not given in my application.
Not written.
So that was 1 or 2, I think.
Can 5379 of 2012.
25 can. 2025 is yeah. Lordship, it was affirmed on the 18th day of February 2025. The section 5 application with a delay of 4 days.
18 February 25, yes.
Yes.
But he has written a number on the top which says 5379 of 2012.
I don't know. That's not with
So
me.
probably a mistake, an error.
That's not in my copy.
In your copy, there is no number.
There is no can number in my copy. It's got the MAT number. Can number is blank.
In 6, there is no can. In 6, there is no can. Then why, how this is in the file? How this is in the file? Check the website whether there is any entry.
There's a supplementary affidavit to that.
There is no.
It was affirmed on the 7th day of March. No, it was taken up for hearing on. It was taken up for hearing. Thereafter, your lordships gave leave to file a supplementary affidavit. He filed a supplementary affidavit.
See, he has served it on your department on 19 February 25. But we are informed that the system is not showing any can.
Not showing a can. Okay.
So if we pass an order, it will be an order passed on which application?
because your lordships had granted him.
In fact, we had requested one advocate to assist him, but I don't know what happened. Perhaps he doesn't want to continue with that advocate. What can be done? It's unnecessarily.
And then there was a supplementary affidavit filed. That is on the 7th day of March 2025, where your lordships had asked him to correct, I mean, because the CAN had said 4 days of delay, and then there was a delay of
31 days. So that has been rectified.
rectified.
But the scan has to be registered before an order can be passed. Yes. This probably the original one he has filed here.
এটার উপরে order হলো যে আমাদের
Get this scan registered. Ask them to put a number on this. Get it back.
লিস্টে এনে তাহলে একটা করে দিন।
Get a CAN number on it and bring it back. Oh, CAN, there is only one copy. You have not filed the CAN application. You have not filed the CAN application.
File application, but on this matter, and my lord,
No, you have not filed. CAN is not numbered.
कैन का नंबर नहीं, कैन का नंबर नहीं, सीधा कैन का नंबर कहाँ है? देखिए ना, ये सेक्शन 5 का कहाँ है? हाँ,
कैन नंबर है?
नंबर है, दिखाइए कोई कैन नंबर दिखाइए, आपके पास कैन नंबर कहाँ? हमको पास भी नहीं है, इधर में भी नहीं है। अब देखिए,
tomorrow I will. My lord, may kindly, if you want this time, I submit the scan number.
Where is the? You have the number. It's not filed. How?
आपके पास 5753
हाँ,
कैन नंबर।
हाँ. Modification application, already I have filed.
না না এখানে কোথায় कैन नंबर? আচ্ছা লর্ডশিপ there is a can 3 ও না না ওটা আগেরটা এটা না না
No, that is in item 5. In 6, there is no CAN.
then let him get
No, how can he? The system is not showing any CAN filed.
কি করেছে Lordship, I believe he has not filed it, he has rubbed it on us. हाँ, आप फाइल नहीं किया कैन हम लोग को कॉपी दिया, फाइल नहीं किया। ना 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 আমাদের সার্ভিস করেছে না না ওটা ফাইলিং হয় সার্ভিস করে আমাদের কপি সার্ভিস করে
There is something wrong. He is correct. No, no. How can it be in the file? This is. Oh no, no, that must be name.
रिसीव किया हम तो बोलते हैं आप भी
हाँ,
आप डिपार्टमेंट में फाइल करने ही किया ठीक से
हमको उतना
वो तो करना ही पड़ेगा
इतना
करेगा
yes, already I have submitted, no doubt.
देखिए
Yes, I will
देखिए
submit it.
हाँ
Yes.
सबमिटेड इतना लड़ाई तो हाल
Yes.
तलवार बिना लड़ाई होगा कैसे
हाँ, yes, no doubt. So many papers are kept in my office.
হ্যাঁ আমি না তখন
We-
দেখে নিয়েছি
we
যখন
unable to interact with him. That is the problem. From where has he got the number? Can he tell us from where he has got that number?
कैन का नंबर कहाँ से मिला आपको
नंबर कहाँ से मिली आपको?
Yes, tomorrow I will submit it, my lord. Make I give time
Otherwise,
for submitting the CAN number.
नंबर आपके पास है?
है आपके पास नंबर वो नंबर है आपके पास He
Next,
says
tomorrow,
yes.
search it and I will submit it in court order.
ये कैन है, दिखाइए.
ये फाइल किया ना इसको कोई नंबर है कैन का ये तो
Sir, make I give me time. Tomorrow I will submit it.
No, you give it. We will get it filed. Don't worry. Get it filed. You already have a copy. You have it filed. You ask them to give it in the filing section. Get a CAN number on that. There is no second copy. Get it filed. Not today, madam. We'll keep it tomorrow.
कल होगा कल होगा
Tell him that it is being filed.
कैन वो फाइल होगा
Tomorrow I will submit it, my lord.
We are getting it filed. Why don't you come with someone? How to?
नंबर का जरूरत नहीं वो ठीक
Let's call the next case. Bonds.
Item number 13. Nine. Item number 9.
Thirteen या 9? 13 या 9? Who is appearing in 9?
Forty-six. Item number 10. আজকে হবে না। হুম হুম পারো হবে।
Yes.
My lord, I am for the respondent relief also.
May it please your lordship. But I'm sorry, my lord, last day I couldn't assist your lordships properly. I think, my lord, today your lordships would, my lord,
We have heard this matter.
to some extent.
Yes. Oh, yes. Now I remember.
But today, possibly, my lord, your lordship could appreciate, my lord, I would somehow, my lord, assist in a position.
No, we had made a specific query to you.
Yes. I would give that answer. that
Yes.
How do I say with regard to that change of, my lord, so far my date of appointment is concerned, that your lordship has put me. Now, my lord, what was the tribunal's order? In the first round of litigations, my lord, which attained finality, it was held that my termination from the service was illegal, non-est in the eyes of law. I was there since 1987.
No, we asked you a simple question.
My lord.
What is the relief you want from the court?
My lord, my relief.
You have been regularized, you have become a Group D employee from a specific date.
Yes.
The order of regularization is at page 57.
Yes. Now, my lord, say for example.
Now, what is wrong with this regularization order?
My lord.
And what was the relief in respect of this regularization order that you brought you before the tribunal?
My lord, the tribunal has itself clarified, which was not followed by the railway administration. May I say like this? Say for example, my lord, somebody joins in a service, my lord, as my lord, a probationary basis from, my lord, say from 1st January 2002.
Probationary and regularization are two different ends of the spectrum.
Very well. My lord, from temporary basis.
Yes.
My lord, he first joined as a casual. He attained, my lord, the position of temporary. Then, my lord, he became, my lord, absorbed on a regular basis.
Which is not the case here.
This is the case here.
No.
Yes, that is the case here. That is the case here. My regularization may be from a date when I became regularized, but my date of original appointment would remain same.
Point is, what difference does it make?
Well, the point of difference is that the entire my pay scale would be different. Well, I would get, well, a notional benefit. My pensionary benefit would I get?
So therefore, is it your submission that the order of regularization has to relate back to some date?
Well, my regularization.
Unless that is accepted or allowed, how can any service be counted? Cannot be.
Well, that has been accepted and allowed. That has, well, that is the tricks that the railway administrations purported.
So where is that showing? Show us any order after this 13th August 2007 allowing counting of the past service as a regular service.
My lord, here, my lord, so far not allowing counting of a past service as a regular service.
Unless it is counted, how any benefit can be given?
My point is that I joined in 1987.
Who is disputing that? Who has disputed that?
My lord, kindly comes to, my lord, the first cat order in my lord's brief. Kindly takes page 18. Kindly takes, my lord, page 19 first. Here, my lord, may I say this? Tribunal held that he already attained temporary status. Now, you do the needful for absorption and hold a screening test. He did, the railway did just exactly the contrary, not in opposite.
Temporary status since which date?
Temporary status since, my lord, from 1987.
Give us the date, sir. Where is that finding of the tribunal and what is the date? Give us the specifics. Don't make general submissions.
My lord, the specific date that the tribunal held over here.
Come to page paragraph 9 of the
But the tribunal held that I get the temporary status in between 1987 and 1988. That was.
So there is no date. Therefore, we were asking you. In between 87 and 88, the tribunal says you obtained a temporary status.
Well, I do not require to produce. They have themselves admitted in the pay slips.
All right. So
may I
therefore,
just say this? May I just say
if you are a temporary, you had a temporary status since 87, 88, why it should be counted now as a part of your regular service post regularization?
Malad, the point is this, Malad, say for example, Malad, why I repeatedly harping on this point, my date of regularization would be one, and my date of original appointment may be not necessarily the same thing. May I just, Malad, place it on a different way, Malad, with my deepest of respect that your lordship come in and item with me. The tribunal held that I already acquired temporary status. Do not needful for regularization. Department did not do that. Department reabsorbed me in a post of substitute, held that I did not acquire temporary status. That is absolutely patently illegal and contrary to the tribunal's
That
order.
is already over. See, again, you are going into history.
No.
That is over. The tribunal said you cannot do
that
this.
was after the tribunal's order. That is what I am trying to impress upon your lordship. That was after the tribunal's order.
Still, if we accept what you are saying, what relief, what effect it will have on your regularization order?
My lord, may I say this?
What is it that you want?
In their own record, my lord, they admitted that I was in the service from 1987.
This is the third time today you are saying that. We are asking you, what is it? What is the effect of that you want from the court? Please tell us. What is the effect of this? The temporary service since 87, 88, regularization in 2007. Yes. Now, what is it that you want? This is an admitted position. Neither they can dispute nor
I want my date of appointment.
Yes.
The date of appointment in the railway service.
Yes.
From 1987 should.
So you want regularization should be relayed back to 87.
I do not say that my regularization should be relayed back to that date.
Then what is the relief that you will get?
My submission is this, that my date of joining, they say my date of joining is from 13/3/2007. I say no, my date of joining is 1987. That is the point, Ballard, I say over here. And that is what was contrary to the tribunal's
Are
order.
you litigating for the sake of litigation?
No,
or you are litigating for some relief?
Ballard, so far as my...
Repeatedly we are asking you, what is the relief that you want?
Ballard, that
you are saying, tell them to say that I've been appointed on such and such date. What is the consequence, sir? What will you get? What is it that you will get?
Well, it kindly comes to paragraph 4 of the tribunal's order that your lordships, Manad, possibly did not look into on the other day. Para 6.
Yes.
The applicant having served the railways during summer months of 1987-1988, he certainly covered 120 days in two spells, entitling him to be treated as a temporary status man. For the reason of the provision para 2006 Roman small 2 A and B of volume 2 of Indian Railway Employees Manual, that under the provisions of para 2005A of said volume 2 of IREM, an elaborate procedure as provided in DNA rules of giving chance of hearing, etc., ought to be followed before terminating a man with temporary status. Accordingly, no such elaborate procedure having been followed before striking off of the name of the applicant, a man deemed to be with temporary status from the roles maintained by the railways, the said action of the respondent railways is bound to be held as bad, being violative of the principle of natural justice, Article 14 of the Constitution of India. Therefore, we hereby set aside and quash the order number such and such dated 26 August 1996, so far as it relates to the applicant, and hold further that his name is deemed to be there in the roll of substitutes. Meaning thereby, my date of joining cannot be ignored from 1987. Even if my regularization is there now, what stand, my lord, they took, according to them, my lord, I did not attain temporary status in one hand. On the other hand,
Argument-
they say I attain temporary status.
The argument is to achieve what end? What is it that you want, please?
My lord, I say, my lord, on a repeated occasion.
What will you get?
That my
What can you get now for the past service? You tell us, where is your prayer in the way? What do you want from the tribunal? Unnecessarily, you are going into history.
my lord, my prayers in the tribunal, so far as implementations of the previous order that has already been passed by the tribunal,
Yes.
and that is quite maintainable, my lord. I do not need to, my lord, press for a contempt in separate. The lordships are well aware there are settled principles of law by the Supreme Court, and this honorable court has also held. A fresh writ petition can always be maintainable. This is my first and principal prayer, that they have to act toto in terms of the tribunal's order. So far as my second prayer is concerned, for an order directing the respondent to treat the continuity of service of the applicant herein from the date of his initial joining with effect from 4/5/1987 as accepted and mentioned in authority in different places. Not only that, upon considerations and exchange of pleadings, the tribunal also held the same thing. Tribunal did not ask them to join me, and thereafter, my lord, considering, my lord, let the temporary status be acquired, and thereafter, my lord, then absorb. This is the difference, my lord, that the railways did contrary to the tribunal's order. Tribunal said, I already acquired temporary status. Now consider him for absorption, do the screening test. They did not do the screening test. They passed a speaking order, say that we could not engage you as a substitute. Subsequently, I preferred an appeal that you are acting contrary to the orders. Then they say, very well, we found that you were there previously. We are now considering to engage you as a substitute. And they engaged me as a substitute from 13/3/2007. Then after 120 days, in terms of this manual, they held that now you acquire temporary status. So we are purporting to comply the tribunal's order, and from 13th August 2007, we treat you as absorbed in a regular basis. That the tribunal never said, my lord. There has been a sea difference with regard to my service and past benefits. So far as my absence is concerned, but so far their reply, your lordship would be pleased to see, even after the tribunal's order, they continue to say that I did not acquire temporary status. The tribunal had nowhere held that I acquired temporary status, and I was to give directly, my lord, the post of absorptions. What tactfully, my lord, they, by doing this, instead of my joining originally from 4th May 1987, they say, no, I joined in the service in 13 March 2007. That is the point of difference. Now, my lord, kindly comes to their own contentions over here at page 19.
If we have understood what you are trying to say, in OA 616 of 2003,
right,
there is a declaration of your temporary status from an earlier date.
Not only that.
Where is that?
The continuity of my service.
After that will come, where is that?
Right.
Show us from the order passed in OA 616 of 2003.
Lordship. Well, may I just first show page 19. So, my lord, I would, my lord, strictly relying on the doctrine of reading down. The judgment which
you have,
Lordship.
The canvas is not so big. You have got an order,
right,
616. Now let us see what is your right determined under 616.
Right. I'm extremely grateful. Kindly comes to, my lord, page 19 first, somewhere in the middle portion, just, my lord, above the middle portion.
Yes.
My lord, this start with due to not attaining the temporary status. Lordship help found, my lord? Page 19.
No, let us see what the tribunal has found. We are not going to look at the submission.
Just give me 1 minute more. Just give me 1 minute more. Considering the railways contentions, I would like to show that. Then, my lord, what the tribunal held. Kindly comes to page 19, the middle portion.
Yes.
Due to not attaining of temporary status. Lordship has found, my lord. So this was the railway's place before the tribunal that
Yes.
my service was turned down on 17/5/2000 with the following words. Due to not attaining of temporary status, your name was not considered for screening towards absorption in the railway from substitute. However, here remaining yourself unauthorizedly absent from duty for indefinite period in view of the above, there is no scope to consider your appeal in present. Now, come to page 18, the first page. Had it been their case, now on reversal, Miller, on the face, kindly see the opening lines, Miller, that the tribunal had recorded. Appellant claims that while serving the railways of temporary status, he had to remain absent for the reasons of his sickness, and during the said period of absence, the steps were taken by the railways for absorbing him. Kindly underline, Miller. In regular establishment for which he was repeatedly summoned on May 92, July 92, October 92, May 94 to face the screening test. By treating his absence to be an unauthorized one, a notice was given to the applicant on 14/6/96 to show cause as to why his name should not be deleted from the list of substitutes. The text of which reads as under: A. You have been asked for screening several times. We did this office letter number such and such dated 91, 92, 92, then 3 times in the 92 and 94, but no response received by this office from your side. Now, my lord, here, considering page 19 and page 18, your lordship would find that there is a hot and blow story, because my termination was on the basis that I did not attend.
So that has been laid to rest
Yes.
by the tribunal's
Now,
finding. Let
yes,
us come
yes,
to the
yes.
finding.
Yes,
That's
now-
immaterial today.
Now, my lord, kindly comes to paragraph 4, page 19. My lord, so far as page 20 is concerned. Kindly see, my lord, page 20.
Have you challenged the order passed in 616?
My lord, this order?
Yes.
No.
Then why are you reading the history? Just come to what the tribunal has concluded. Why should we go into the entire thing? What right the tribunal has declared? Come to it.
Now, my lord, kindly see. After this, my lord, the submissions recorded at
Come to paragraph 8.
No, my lord, before that, kindly see paragraph
Why
6.
should we, sir? Let us see what the tribunal has
No.
determined.
Whatever
Whatever may have been canvassed by the either parties, how is it relevant
the
today?
first determinations held at paragraph 6.
Let us see.
Yes. After, my lord, reading, considering, then tribunal held at 6. The applicant having served the railways during summer months of 1987-88, he certainly covered 120 days in 2 spells, entitling him to be treated as a temporary status for the reasons of the provision such and such. Then under the paragraph such and such of IREM, the elaborate procedure as provided in DA rules ought to be followed before terminating a man with temporary status. So meaning thereby, my lord, I was held to be continued in service. Apparently, no such elaborate procedure have been followed before striking off the name of the applicant. A man doomed to be a temporary status from the roles maintained by the railways, the said action of the railways is bound to be held is bad, being violative of the principle of naturality. Therefore, we hereby set aside the order dated 96 relates to the applicant and hold further that his name is deemed to be there in the role of substitute.
This is what the tribunal has found.
Yes, before that,
No temporary status.
the temporary status,
Unnecessarily, you are saying that we should read
that
a
has
temporary
already been held.
That is your submission. Yes.
Lordships are well aware that I cannot read in disjunctively. I have to read conjunctively.
Yes.
The document has to be read as a whole.
Yes.
Now, my lord, here,
Finding is
first,
that you are a substitute. From
Well,
there,
my lord,
this finding is consistent to paragraph 9. There is no difference whatsoever.
my lord,
Therefore, we ask you at the outset, did you challenge this order?
No, because
Then
with the deepest of respect, my
this
lord,
is not
this
the proceeding where we can look
no,
into it.
this judgment, my lord, conclusive.
This is final and binding inter parties.
Yes.
Yes.
And I say, my lord, these judgments.
So now let us see what is the infirmity in the present order.
Now,
come-
my lord, please before that, there has to be a 2 status held.
Yes.
One, my lord, that I held temporary status, and second, my lord, I continue to be in service.
Yes.
I'll come back after 5 minutes.
Yes.
Well, as correctly pointed out by your lordships, that in paragraph 6, it says that my name remained as in the role of substitute. Now, my name remained, well, it is immaterial whether I remained as waterman or I remained as substitute. The point is that whether I acquired temporary status or not. Now, my lord, keep this paragraph 6 once. Now, my lord, read para 7. It is also seen that the applicant offered to resume duty after obtaining treatment for his sickness, which prayer was apparently not allowed on flimsy ground that he was treated by some private medical practitioner. Not allowing one to resume duty amounts to termination of service. But such termination is bound to be termed honest when it is the outcome of violation of natural justice in the statute book as extracted in para 4 and discussed in para 6 above. In one hand, the railways state that the applicant had no temporary status, and on the other hand, they expected him to visit the railway doctor. This is like blowing hot and cold. Now, my lord, kindly skip that next 4-5 lines, then come to next page. Second line from the top. When it is the case of the respondent that the applicant remained absent from 1989 and he placed material such and such to show that he was under medical treatment of his sickness between 90 to 95, his name was in the role of substitute to be engaged as and when regular hand remains absent. It has not been pointed out by the respondent that in between 89 and 90, they have ever offered any job to be discharged as a substitute to the applicant, which he failed to do for being absent. Then, such and such, without offering any engagement, then, the last sentence of this paragraph, thus, the plea of absence in the circumstances cannot be a ground to terminate the service of the applicant. Now, para 8, having held that the applicant acquired temporary status. So, my lord, the temporary status has already been held. Now, my lord, my position was changed from waterman to substitute. Now, lordship may recall the first opening lines, my lord, of the judgment, which says, according to the railways, that they called me for, my lord, for being regularized. A persons could be regularized only on becoming, my lord, attaining the status of temporary. That is, my lord, the rule statute of the Indian Railway itself says. Having held that the applicant acquired temporary status on completion of more than 120 days of service as a hot waterman during 87-88, even before engaged as a substitute in March 1988. And the action of the respondent railway pertaining to the striking of the name of the applicant from the rolls to be bad and honest and now stands quashed, we now proceed to examine the grievances of the applicant pertaining to regularization. Now, my lord, kindly think of a situations. It is not a case that I remained as a casual or my lord, termination was held to be valid in the eyes of law. It is a consistent stand of the railways in two different ways, that either I did not acquire temporary status and on the contrary, I attained temporary status. That is why they called me, but no documents could be produced. The tribunal disbelieved the case and also found, my lord, my termination is bad according to para 2005 and 2006 of the Indian Railway, my lord, Employees Manual, which says, my lord, certain procedures have to be followed, which was not done. So, my case on being, my lord, passing of the tribunal's order and on finding of this, maybe this, my lord, that your lordship were pleased to look into that where the tribunal held that I got a temporary status. The tribunal has held that I got a temporary status by the actions and by the contemporaneous materials on record. And after being waterman, my lord, for certain period and on the position that I held on that day, my lord, I got this status. Thereafter, I shifted to the post of substitute, and there, my lord, I remained absent for certain dates, and thereafter, my lord, they terminated my service, which held to be bad. Now, here, my lord, the tribunal says of the name of the applicant from the rolls to be bad and honest and now stand quashed. Now we proceed to examine the grievance of the applicant pertaining to regularization. It is the case of the railways that the applicant was repeatedly called when his name was in the roll to face the screening test, to be regularized, to be absorbed in regular establishment. it is the positive case of the applicant that no such notices were ever received by him. The respondent have placed no materials to substantiate their stand. Therefore, the respondent should now give a fresh opportunity to the applicant to face the screening.
Sentence.
Yes.
After an entire history, what this court has said. Therefore,
the applicant, the respondent should now give a fresh opportunity.
fresh, nothing of the past.
My lord, my reading
Sir,
to the extent, my lord.
Your reading cannot, this judgment is what a judgment says.
Yes.
And a judgment is what a judgment directs.
My lord, fresh
You
opportunity.
cannot go into an interpretation of a judgment which you have accepted as it is, never assailed.
My lord,
This we said at the very outset.
my lord, this not only me, my lord, the railways have also accepted.
Yes.
Fresh.
Exactly, both of
fresh,
you.
Exact, my lord. Fresh.
So therefore, fresh, nothing from prior to 26/5/2006, there is nothing.
No, my lord, there is a point of difference, my lord. The deepest of respect, your lordship would definitely come in ad idem, my lord, with me.
Yes.
Fresh to the extent that.
All right. So therefore, we can go into an interpretation of the judgment.
No, I do not say even that.
Therefore, a judgment is what a judgment says.
Yes,
That is a settled proposition of
lordship cannot substitute
correct
different opinion.
So there is this is what the judgment says.
Exactly.
That you are only entitled to a fresh consideration.
No, fresh consideration for what?
Exactly.
For
Now read what it says. Therefore,
yes. Therefore, the respondent should now give a fresh opportunity to the applicant to face the screening for being regularized.
Yes, that's it.
So
now let us proceed.
Now, may I just add over here?
Now read the next paragraph.
Yes.
It further clarifies.
Consequence, it is held that the applicant acquired a temporary status.
Yes.
Under the railways before being engaged to be a substitute.
Yes.
And that his name continues to be in the role of substitute.
All right.
For which he should now be given engagement as a substitute.
Yes.
So there is a
tribunal
status quo ante.
Tribunal says you continue to be a substitute and be given an engagement as substitute.
So the position is a status quo ante.
So the judgment is in two parts. The tribunal says that you could not have held him to be discontinued as substitute. Why it has said so? It is clear. It says a substitute is just on the rolls waiting for work to be assigned.
There are two more points.
If you have not assigned work for 5 years, you cannot say he was absent. This is what the tribunal has said in substance. Because unless you assign him a work, where is the question of saying that he was absent? Therefore, tribunal says you continue to be a substitute. You are entitled to be considered for regularization fresh. You want us to read in this that we should take from 87, 88.
No, Mother.
Which we find it difficult for you.
I say with the deepest of respect, there are two more caveats over here.
Yes.
My name continue to be in the role. It is irrespective.
How many times?
How
many times you will say that? Yes.
Whether it is a substitute or waterman. Kindly forget for the time being.
So the tribunal direction is clear. Now let us proceed.
Yes. Now, may I just say that there are two caveats. Lordships are absolutely correct that my positions, is according to the tribunal's order, it has been a status quo ante. The positions was restored.
We are not saying so. We are not saying so.
But the tribunal has
we are
said
being misunderstood.
No, but the tribunal has said so.
Tribunal says continue as a status of what do they substitute?
The tribunal said one
substitute substitute temporary status to be
exactly this.
Exactly. And to be considered for regularization afresh.
Now, if I am to be
so
held,
therefore again we are coming to the same question which you asked you in the beginning. How can you get, under which provision you will get a benefit of any service prior to regularization? You are not telling us anything about that. You are arguing these things which today mean nothing. 616 is over, not challenged, binding inter partes.
Your lordships have, with the deepest of respect, my lord's own wisdom, accepted that a tribunal considered that my temporary status remained.
No, we have accepted that in spite of all this finding, tribunal says to consider your case for regularization afresh.
For which?
So therefore, under which provision you will get any benefit of the past service? Show us. We have been asking you repeatedly.
For which? That temporary status has already been get. That
you may continue saying that many times. We are still asking you under which provision you will get a benefit of this period. That you are not showing us.
May I just say this? there has to be a date from my joining, and there has to be a date when I got the temporary status. And only on the
That is
basis
not
of
the
that, I
issue
could
here,
be
sir. We
considered.
are asking you under which provision you claim a benefit of the period prior to order of regularization. And what is that benefit that you want?
Well, that is what I am coming, Milord. That is what. Kindly give me, Milord, 1 minute. Milord, here the tribunal did not say that I did not acquire temporary status. Milord,
Why are you unnecessarily repeating the same thing n number of times? You have already said this. Your specific case is tribunal has recognized my temporary status since 87, 88. By saying it 10 times, it does not change. It remains the same. We are asking you, if this is so according to you, under which provision you will get any benefit that you are asking, and what is the benefit that you want?
Milord, kindly comes to page 26
Yes.
of my lord's brief.
What is that page 26?
This is a purporting speaking order. The tribunal did not say that you considered him to give him a temporary status. Kindly see what the order says. 25/9/2006, they purportedly said that we constitute a screening committee. Sri such and such was allowed to appear. However, the screening committee did not recommend his name for regularization on the following amongst others. I could not able to produce my initial authority for engagement, which is the prime document for being considered for regularization.
See, the tribunal's order is of May 2006.
Yes.
Regularization is of August 2007.
Yes.
So what is the time gap?
Well, here they
15
say
months. The tribunal directed to undertake that exercise within a stipulated
I did
period.
not say, my lord, that exercising of 15 months or 20 months. I say the tribunal held that I already acquired temporary status. They say I did not acquire temporary status.
Why? We have understood that. Why are you
My lord,
repeatedly saying the same
date
thing?
of my temporary status would mean they
We are asking you what you want and what you will get. Under which provision, show us.
My lord, my original date of appointment and
All
when
right, 87 is your original date of appointment.
and when
So
did
what
I
do you
acquire?
want from 87?
And when, my lord, that would entirely change, my lord, my pay protections and my pensionary benefits because of the fact
Under which provision, sir? Where is the provision that such temporary service is to be counted as part of your regular service, or a pay fixation is to be done taking into consideration? Just show us first.
my lord, so far as their document itself say that I am entitled, my lord, so far as this consideration has to be
So
made.
then
from
we'll
the
take
date
it.
of-
There is no provision on which you are relying. We
No.
have asked you sufficient number of times.
My lord, kindly then comes to their Indian Railway Employees Manual.
Yes, show us the which provision.
এই supplementary affidavit তোমাদের employees railway তোমার manual দিদি
Supplementary, he is showing the supplementary affidavit, my lord.
But I am not showing a supplementary affidavit. We prepared the supplementary affidavit pursuant to the previous order passed by a coordinate bench. In that supplementary affidavit, we also enclosed, my lord,
What is the date of the supplementary?
no, supplementary affidavit has not yet filed, my lord, because on the other day, Lordship said very well, let us proceed. If we require, then we shall take the supplementary affidavit on record. Now, we are only showing the provisions of Indian.
See, any provision which is applicable in the organization need not be filed by supplementary affidavit. You show us, give us a copy of the rule.
Kindly comes to, my lord.
We are not going to allow anything which was not before the tribunal. Provisions, rules,
No,
whatever
these
it
are not
is, we
tribunal.
will.
These are the pleadings which were used before the tribunal. The coordinate bench wanted to see those pleadings.
Let us see then. You have served a copy. We asked you, have you served a copy?
Well, we are serving hearing now. My lord, kindly takes
Which provision in which railway manual?
Indian Railway, my lord, employees manual kindly comes to page 51. Have you lordship found, my lord? 2005. Establishment and privileges admissible to casual labor who are treated as temporary, that is given temporary status after the completion of 120 days or 360 days of continuous employment as the case may be. Casual labor treated as temporary are entitled to the rights and benefits admissible to temporary railway servants as laid down in chapter such and such of this manual. The rights and privileges admissible to such labor also include the benefit of dearness allowance, DNA rules. However, this service prior to absorption in temporary, permanent, and regular cadre after the required selection screening of will not count for the purpose of seniority, and the date of their regular appointment after the screening selection shall determine their seniority vis-a-vis other regular temporary employees. This is, however, subject to the provision that if the seniority of certain individual employees has already been determined in any other manner, either in pursuance of the judicial decisions or otherwise, the seniority so determined shall not be altered. Casual labor, including project casual labor, shall be eligible to count only half the period of service rendered by him after attaining temporary status on completion of prescribed days of continuous employment and before regular absorption as qualifying service for the purpose of pensionary benefits. Kindly underline this, Malad, for the purpose of pensionary benefits. This benefit will be admissible only after the absorption in the regular employment. Such casual labor who have attained temporary status will also be entitled to carry forward the leave at their credit to new post on absorption in regular service. Daily rated casual will not be entitled to those benefits. Such casual labor who acquire temporary status will not, however, be brought onto the permanent or regular establishment or treated as in regular employment on railways until and unless they are selected through regular selection board for Group D post in the manner laid down from time to time, subject to such orders as the railway board may from time to time, and subject to such exception and conditions like appointment on compassionate ground. Quotas for handicapped ex-service may be specified in these orders. They will a prior claim others to recruitment on a regular basis, and they will be considered for regular employment without having going through the employment exchange. Such of them who join as casual labor before attaining the age of 20 years should be allowed relaxation of maximum age limit prescribed for Group D post to the extent of their total service, which may either continuous or in broken records. No temporary post should be created to accommodate such casual labor who acquire temporary status for conferment of attendant benefits like regular scale of pay, increment, etc. After the absorption in regular employment, half of the service rendered after attaining temporary status by such person before regular absorption against a regular, temporary, and permanent post will qualify for pensionary benefits subject to the conditions prescribed in the railway board letter dated 14/10/80 in the case of project casual labor. Casual labor who have acquired temporary status and put in 3 years of continuous service should be treated at par with temporary railway employees for the purpose of festival allowance, advance, food advance on some conditions, same conditions as are applicable to railway temporary railway servants for grant of such advance provided they furnish two sureties from railway permanent employees. Casual labor engaged on works who attain temporary status on completion of 120 days, continuous employment on some type of work should be treated as temporary employees for the purpose of hospital leave in terms of rules such and such. A casual labor who has attained temporary status and has been paid regular scale of pay when re-engaged and after having discharged earlier on completion of work for non-availability of further productive work may be started on the pay last down by him. This shall be effected from 2nd October 1980. Then 2006 manual, the number 2006, absorption of casual labor in regular vacancy. Absorption of casual labor in regular vacancy Group D employment may be considered in accordance with the instruction issued by the Railway Board from time to time. Such absorption is, however, not automatic but is subject inter alia to availability of vacancy and suitability and eligibility of individual casual labor and rules regarding seniority, unit method of absorption, etc., decided by the Railway Administration. Casual watermen for summer season shall be eligible for temporary status on completion of 120 days of continuous employment. B. For this purpose, various spells of engagement as casual watermen may be aggregated, provided the gap between two spells of employment has been caused due to the season being over and there being no work for them for such establishment, provided further that if a person engaged in the previous years is given an opportunity to work in the same hot weather establishment in the subsequent year, but he fails to avail that opportunity, he will have to start afresh in the event of his being so engaged again in future sessions. The provisions are effective from the summer session 1995 as long as it is established that a casual labor has been enrolled with the prescribed age limit. Relaxation is upper age limit at the same time of actual absorption should be automatic and guided by this factor. In old cases where the age limit was not observed, relaxation of age should be considered sympathetically. The DRMs may exercise such powers to grant relaxation in age limit. Now, Millard, this 2005 and 2006, these all were considered, Millard, in the tribunal's order passed in 2006 and extracted apropos in verbatim in paragraph 4. Your Lordship would also see, Millard, these were also considered. And having held so, Millard, your Lordship may kindly see para 4, Millard, page 20 and 21.
Yes.
Have you Lordship found, Millard? So, considering this statutory manual and the aspects, Millard, of my reckoning service and having got the benefits of already, Millard, acquiring temporary status, where, Millard, the railways took, Millard, at double standards, which was, Millard, not appreciated, Millard, and turned down. And I was set to consider for absorptions a fresh opportunity, meaning according to them, they have already given me opportunity. I did not avail it. The tribunal said there are no contemporaneous materials on record that he failed to avail. Very well, give him a fresh opportunity. So the reading down of the documents may be like this, my lord. The fresh opportunity means it doesn't say or denotes that give him a job afresh. He is already in the job, he is already in the payroll, he is already continuously in service. So far as his prolonged absence, 5 years if any, you could not substantiate that it was willful or something malafide. Here, my lord, you could not even say, and here, my lord, tribunal most interestingly say that you once said that he has no temporary status even, and you believe him to go to the railway doctor because the railway doctor could not see him. Here, my lord, a fresh opportunity for being regularized. What they say? To give him a temporary status before being regularized. So instead of for being regularized, they held me before being regularized. I would show from the reply. And the status which I acquired and the benefits which I, by default, if I say this with all humiliation, by default I obtained, which, my lord, attains finality for both parties, that was said to be upset. My date of joining, if be changed, then I would lose all service benefits which I have otherwise entitled to. and which I am held to be entitled by the tribunal, sir. And on the same point, my lord, may I also, my lord, if your lordship kindly, my lord, turns to the next page, page 53, there is also a judgment of the Honorable Supreme Court.
No judgment or no judgment. You are so there. This is what we have been asking you unnecessarily. We have taken so long.
But I'm sorry, but
Wanted to know what you want.
my lord.
Now you're telling us.
No, I'm sorry, my lord, extremely, my lord, if I could not, my lord, match with your, my lord, lordship's, my lord. Now, kindly takes up, my lord, page 26. So, upon being
Only
held,
issue is whether as a result of the order passed in 616,
lordship,
the past service can be obliterated or is required to be considered for this
and
purpose.
yeah,
That's all.
and my lord, I would also add one more issue subject to my lord's consideration. From their records, they somehow consider.
Forget about it. It has never been considered. Where's the question of going into records? Neither you argued before the tribunal in these proceedings, nor they have considered.
No, I argued.
Where is it? Show from the present order where you have argued about any benefit under this provision.
Yes. That was my case even.
Oh, let us see.
My lord,
The order is sacrosanct. You know that.
my lord,
And
kindly
if
comes,
it-
kindly comes to, my lord, the prayers portion. What
Sir,
did I,
you please come to the order of the tribunal.
my lord, kindly comes
Where
to,
have you argued for such benefit?
my lord, kindly comes to paragraph 4 at page 3.
Yes. There's not even a mention of this IREM. That's why we were asking you, what is it you want?
I'm extremely grateful. Kindly see, my lord, paragraph 4 in at page 3.
Yes.
First, second paragraph, can you skip over? The applicant was engaged as hot weather staff. Lordship has got, my lord. In the year 1987, as he happened to be a retired employee's son, subsequently with a order dated 13th August 2007, he was regularized in service. During the period between 87 and 2007, the applicant
All
had,
right. So, if we have understood this, what you have read correctly, you are saying 50% of this service should be added as your pensionable service for the purpose of qualifying service. Then you say there is a fixation of dearness and other allowances. Where has that been rejected? And who has considered and rejected that claim?
my lord, they considered me not to be, my lord, engaged from 87, but considered me to be engaged from.
That is not to be said in the regularization order. That is not to be said in the regularization. And how long do you have before you superannuate?
I have already superannuated.
When?
That, my lord,
So are you getting pension?
no, because I would not have.
So
According to
where
this-
have you approached the authorities that why you have not given this benefit to me? Where is that demand from you and where is the refusal by the authorities?
My lord, this is so far as the benefits are concerned. May I just check, my lord? Page 55.
This is not this is a screening test, sir.
May I just? My lord, kindly comes to page 41. My lord, one is at page 45. My yes, prior to that, my lord, kindly see page 44, 44, 43. it starts from 42 onwards.
So have they ever passed any order on these representations filed by you?
Well, this was repeatedly going on till page 55. Page 56 is a 2-sentence communication that it has sent for the competent authority, where nothing has come up, then I filed the way. And according to the tribunal's second round of litigations, nothing was there in the previous round of litigation.
Where is that amendment in your OA now? Come to your OA.
My
Present OA. Don't go to the earlier way.
present way. And I would show the
Please show us
I would
first.
also show their reply.
Show us what we are asking, then we'll go to the reply.
Very.
All right, page 28. Now, where is the reply? What is the reply to 4K?
This part is reply, and the front.
We have the reply. Why you are giving us? See here.
Reply is there. Reply.
Yes, we have the reply.
Will not kindly see, it is a reply OA of 2011.
Where have they dealt with para 4K?
Kindly see, my lord, first takes up
page 10 of their reply, paragraph 13.
Prior to that, kindly see paragraph 3. No, Lordship is looking into paragraph 29. What you have said, madam?
Your OA, page 25 of the brief.
Yes.
Sorry, not 25. 27 of the brief. Where is that? K at 28. Page 28.
Yes. Yes. Yes.
Now the reply is at page 10 of their reply.
Yes.
Paragraph 13.
Yes.
Is it?
I deny and dispute the same, excepting those are materials on record.
You have not done anything. He has made a specific.
And out of fairness, my lord, if I say this, being my lord's officer, Lordship may from para 3, page 3, this reply. They were trying to say that my temporary status, my lord, consideration of my temporary status arose after the tribunal's order. If Lordship see, my lord, page 3, second paragraph.
The issue has not been decided by the tribunal.
Very.
This is what we wanted you to show us. That what is the relief that you want?
My lord.
Paragraph 3 starts from which page? Page 2.
Page 2. my lord, one sentence, my lord, page 6.
Yes. What is there?
After giving, my lord, dates for the 4 lines, kindly record what they say. He did not attain temporary status. Lordship has marked it. So that is how I am, my lord, prejudiced. That is my cause of action. That is how I become an agreed person. And that is why, my lord, I reapproach to the tribunal to say that, see, your orders are being flouted and not being carried out in its true spirits and manner.
Yes. That's all.
For the time,
Or anything.
if lordships need me, but I would try to, my lord, rely on the judgment on the doctrine of reading down and, my lord, harmonious constructions.
Show us.
Well, one judgment that I have already, my lord, shown, my lord, to your lordship, my lord, that the copy that I have referred.
The one after the IREM.
Yes. Because this benefits, my lord, are to be statutory. If your lordships, my lord, I'm sorry, my lord, the pages are not so legible.
Yes, very difficult. Anyway, the citation is there. So
Yes,
we can.
EIR 1982 Supreme Court 854.
So what is the point you want to make
But
by
the point, my lord, the benefits that the temporary employees, my lord, on being, my lord, having the status, that cannot be denuded, my lord.
so that has not been considered
Yes.
by the forum altogether.
Now, my lord, so far as
The tribunal has not even accepted their stand in this regard. It could have said that you are correct. He will be considered afresh because of the tribunal's order in 2006. Therefore, he is not entitled to anything. Tribunal has not said so. What the tribunal has said.
now, my lord, here, my lord, 1995 volume 6. दिए था वो?
That also you have given us.
I have not given this. अच्छा दिए था? हाँ. This is attaining finality and binding on the state, my lord. This is a doctrine of reading down. The provisions of the statute even impugned to the extent, my lord, they deprive petitioners from the benefit of the judgment of court, which had become final. I rely on, my lord, paragraph 12.
And the earlier judgment, you did not tell us which paragraph you are relying upon.
I'm sorry, extremely sorry. It's my mistake, my lord. Kindly pardon me, my lord. I rely on my lord, paragraph 11. '20 and 21. Well, here, para 11, as I, my lord, indicated, the last portions, my lord, on the left column. Last portion of the left column, just for the time being, my lord.
Which, where?
This judgment, my lord.
The second one.
Second one. AIR 78. Lordship. In a supplementary, is a part of a supplementary. That is what I said, my lord, 11, 20, and 21.
Yes.
Now, page 1982. Oh, page 60, running page 60. Running page 60.
Yes.
Is the end of para 11, my lord, left side.
Yes.
Is also, my lord, underlined portions, my lord.
Yes.
It is thus abundantly clear that if a person belonging to the category of casual labor employed in such and work other than such and such with a break by such and be treated as a temporary railway servant after the expiry period such and such, it is equally or even mentioned once the person acquired the status of a temporary railway servant by operation of law, the condition of his service would be governed as set out in chapter 13. That is what I have shown to your lordship. And my lord, 11. After that, my lord, paragraph 20, 21. And my lord, kindly see 23. I also, my lord, I ought to have 23 and 23. Lordship has seen 23? 63, running page 63. Lordship has found, my lord? Page 63. Now, if the appellant had become at least a temporary servant, he is entitled to many benefits as set out in Rule 2303 onwards. I have shown to your lordships. We have no doubt in our mind that the appellant whose case was...
We have understood what you're trying to say. In your OA, what is that specific period which you say is to be worked out in terms of the IREM? Come to that, show us from the OA. What is the exact period that you are claiming has to be worked out and 50% counted as qualifying service and other benefits given? Which period?
But from my first engagement on 4th May 1987 and having exactly K, the para K that your lordships have pointed out.
In that only, that is
yes,
the one.
Yes. That was my sheet anchor. There are other parts, but that is the entire thing is boiled down there. I was so grateful that your lordships have itself pointed out, my lord, here, and lordship has also seen their reply. My first engagement as on 4/5/1987 and the temporary status with effect from 10/10/1987. And two more documents, their own pay slips at page 16 and 17. Immediate after this OA. That was also a part of OA annexures. Their own certifications, that page 16, 17. After this, after the end of the way. My first annexure placed before the tribunal.
This is of 2006.
No. This was further reaffirmed, re-verified. Kindly see, my lord, column 3, date of first engagement, 24th May 2007.
Where is that?
Column 3, page 16. Somewhere in the middle portion. 4th May.
It is of 2006, but don't say no. It is recording things of the past. But
exactly, recording things of the past. Here, the date of engagement, 4th May 1987. And there, my lord, at the end of the page, my counting days was 316. And my lord, kindly transfer to the next page.
This is I see up till 88. This is not beyond 88.
But it is what, my lord, I got from there, and kindly see page 17. At the bottom portion, total work under CIT. Lordship has found, my lord?
That is in 87, 88.
No. What I try to show, my lord, after 120 days, temporary status with effect from 10th October 1987. Lordship has found, my lord? The line. After 120 days, temporary status from 10th October 1987. Lordship has found it. And this is the same thing at para K. What I said.
This was later denied to you and then the tribunal's order was passed. This has not continued.
But they cannot go beyond their own records. And this is, my lord, after, my lord, your lordships are absolutely correct. Whatever the tribunal had passed an order, my lord, in 2006, none of the parties, my lord, can go beyond it.
Yes, you cannot neither.
Yes, that is what my point. The tribunal held, I already acquired temporary status. Now, the point is, when did I acquire?
Benefit is to be given from which date? These documents that you are referring to, therefore we ask you.
No, I am not. I am just only, my lord, supplementing what I said.
No, but
I am
unless you have a specific claim, what can they
No,
consider?
I have a specific claim, my lord. The para K, I have a specific claim that this has to be reckoned. What I say, my lord,
So after
the denial is evasive.
after this 87, 88, you have nothing.
No,
Because of you are admitted position is you were treated as
no. After 87, 89, my lord, then again, my lord, in 91, 92, I had again worked for some days.
so.
Then, my lord, I was absent for 5 years.
That
Then
was
I
in which period?
March 89 to May 95.
No, my lord, she is wrong, my lord. It is, my lord, from '90 to '95.
That was the sickness period.
Sickness period.
Your
And after that, I wanted to join, but they did not allow. And then, my lord, the issues boiled down. In any event, my lord, my rights which are already
And
accrued, that cannot be, my lord, taken away.
90 to 95 when you were not held by them to be not in temporary or any kind of service.
No, they did not ask for that. That was the tribunal's finding.
Correct. So that the tribunal said that he cannot be considered as being absent
Exactly.
because you did not give him work.
And he continues to be in the role.
Oh, yes.
Now, my lord, with the deepest of respect, law is also is well settled that even a wrong order is binding on the parties. It attains finality.
Yes, why have you not considered any benefit?
My lord, let me
My
come
lord, with the
back.
deepest of respect, may I just come back, my lord? I have a 1 p.m. fixed matter. If lordship allows me, my lord, I would be having a
No, we will not. This is not the way.
The poor lawyers, my lord, would get if not getting.
Poor lawyers don't have to run from one court to the other.
1 p.m. fixed matter at court 38, my lord. I would just go and come back. And if your lordship wants my
Come back.
presence, my lord, I would.
My lord, let me come back another day, my lord. I will consider the supplementary affidavit filed by.
Nothing new, my lord.
The
My lord, may I go?
some
Item number 12.
Not real, my lord, for the petitioner, my lord, I'm led by Ms. Sharadatto. My lord, if your lordship kindly see the last order passed by your lordship, my lord, there was a application of a matter, my lord, pen. My lord, till date, my lord, no instruction we have received, my lord. They are just a few minutes ago, I have received on WhatsApp, my lord. 2 days later, my lord, due to the heavy rain, my lord, I am unable to get it printed out, my lord. If your lordship want to see, my lord, no status, my lord, no updated status, my lord. It will take some more time, my lord. That is the reason.
So it is pending.
It is pending, my lord.
But that is what we wanted to know.
Pending, my lord, but the current situation of the matter, my lord, what is the stage, my lord? That is
What situation here? Only it is after it is decided we are to take up.
yes.
So if it is pending, that is what we are asking you. Once we have said it is to be listed after disposal. If it is not disposed of, then same order has to be passed.
Yes, ma'am.
It's not disposed of. Yes, we are informed that the WP number.
Item 13.
For the petitioner.
You have completed. Yes.
I will just add one thing. Well, my right is based on promissory principle of promissory estoppel and equity. Nothing more.
We would rather not go on that. We are being very clear. Prima facie, we would rather not go on that. In the OA, they have come out with a calculation.
My lord.
Where is the question of looking into what happened in the past? If that is the calculation, that is why we asked him if he has given a calculation, how he can resist the benefits arising from such calculation. Page 167 of the brief.
Sir, page 165.
Yes.
After verification, 165.
No, 167 is a calculation where you show that in 92 his basic pay is 2070.
2070, page 168.
Yes. So if this is your own calculation in the reply, then why you are not giving him this amount?
Sir, can you see what is the challenge in the order? This rate petition has filed against the order number 4, not in the original application, in a miscellaneous application. This order, which has been impugned before your lordship, this order has been passed by the learned tribunal in application for clarification or modification of the order passed by the tribunal or passed by the High Court. First petition in the single bench, then matter in 1988, then matter division bench, then division bench order was not contempt was made absolute against the state preferred an appeal. Appeal was allowed. Then he filed the original application against the original order passed by the tribunal. He approached the honorable court. That application was rejected. Then when it again filed an original application, application for clarification that was disposed of. Then he filed an application for MA number 86 of 2011 at page 200.
My prayer, my lord, specifically says that I am challenging the order dated 17 September 2010.
No.
Prayer.
Page 204.
No, that is not their calculation. That we are sorry. That 168 is not their calculation.
Page 204, middle portion.
168 is the calculation. 168 is the calculation that your lawyer has submitted. Their calculation is at 165. And that ends at 166, 1850. So probably they are saying that your lawyer has submitted
1650 our calculation and his calculation is
because the heading is at page 167. Basis of calculation shown in the annexure submitted by the advocate on behalf of Gurudas. This is not their calculation.
on first May 1992, 1800.
This is the calculation which they have said you have resorted to a misrepresentation because this is not the calculation that they had submitted.
Yes.
You have made it and you have submitted in the tribunal. Therefore, equity is against you.
So that was my issue, that maybe I could have, that was a mistake I could, but my fact is corroborated with the observations of the Honorable Court.
It is there in the judgment.
Yes, ma'am. It is corroborated that indeed a chart was filed. Maybe this particular chart was not filed, but a chart was filed which claimed that it was 2070.
But that was not accepted by the court.
Well, I am saying is, as I said, my lord, my claim is very limited, absolutely limited, my lord. I am not expanding it. It is based that only on that you made a particular representation before the court during a proceeding. You have said that this should be my pay scale as on a particular date. I am invoking promissory estoppel. I have lost in everything else I have lost. At least give me that. This is my claim. It has always been my claim, but the trial court went on a different thing. It said it is barred by res judicata. It did not.
Even if it is not barred by res judicata, so many things are represented in a court proceedings. Can any particular representation be fastened upon the person making it if the court has not accepted such a submission?
Well, that is why I am saying that it is more of an equitable right. Before the Honorable High Court somebody makes a representation, I have the right to claim on the basis of that.
Yes.
Equitable right, my lord, and promissory estoppel, nothing more. It's very limited right. My lord.
I can see the order of 16th August 2001.
Where is that?
Page 87.
Page 87.
After the order of the Supreme Court,
16/8/2001.
16th August 2001.
Yes.
WPST number 3 1990. Page 89. Page 89. Bench Preserver Justice Kobe and Justice Basu. Was given liberty to prepare the pension paper. But this fiction is against an order, the original order but passed in a MA number 86 of 2011. MA number 86 of 2011.
86 of 2011. Yes.
Yeah. Arising out of OA number 960 of 2003. After the disposal by the High Court. Justice Joshua Banerjee, I'll see the order passed by Justice Banerjee. Page 191. number 35 of whether you will dismiss as withdrawn. Then 35. In Justice Banerjee said, page 197. We have considered the rival contention. It is true that the appellant's prayer was allowed to the extent of a refund of rupees 3,600 to that extent, the application is allowed. However, tribunal rejected the principal prayer or appreciation of pension. The tribunal observed that material facts are not placed in the court as such. However, the petitioner read that the wrong appreciation facts will make the disposal of petition by recording sufficient evidence, whatever. No further clarification is necessary. Then, Magar, tribunal is resolved. No clarification is necessary.
Learned tribunal clarify
Item number 7 for judgment.
Which the tribunal directed to be considered. Anything has happened on that?
The railway has already given that.
Both those, the extra leave and that
4 days casual leave and double transportation.
already granted.
Already came granted.
So then that we will add in this. Otherwise, we are dismissing your appeal. We have held that in terms of Master Circular 25, he is entitled, irrespective of the provisions contained in 95.
Great. May I give that order?
Please. Not required. We'll just record your submission. It is not in dispute that the other benefits have been granted. Appeal writ petition dismissed. Send it. Original say.
Matter 1 and 2, appeals from orders Sajol Datto.
My lord, I appeal for the appellant in the matter.
Would we? Or the last, sorry.
Yes.
My lord, on the last occasion, if I remember it correctly, I concluded, or I was placing before your lordships the Supreme Court judgment only, my lord. A part of it, my lord, if your lordships are pleased to take up the compilation, the first compilation.
Yes, we had gone through it.
Yes, kindly come to page 38, my lord. This is what I, my lord, possibly placed before your lordships on the last occasion, or I started placing.
Yes, paragraph 46 you had placed.
Yes. My lord, kindly once come to, my lord.
Paragraph 46, 47, 48 you had
47,
placed.
yes, my lord. Once, my lord, page 38, my lord, placitum F. The sentence starting with, then too the respondents did not feel satisfied and filed a third writ petition on
Present writ petition.
Present writ petition.
This you have placed.
And thereafter, my lord, it goes on to say, therefore, the persistent effort was made by the respondents by filing one after another writ petition
before the High Court to somehow reduce the shareholding of appellant. Number one. These attempts speak volume of the subtle design on the part of the respondent. Number two, to somehow see that the holdings of the appellant number one is reduced and the management is passed on to him, to his hands, by outstripping appellant number one from the office of the managing director by purchasing majority of shareholding. Pursuant to the resolution passed on 19th April 95, he wanted to control the entire company. The filing of the repeated writ petition in Calcutta High Court at the expenses of the company adversely affected the interest of the company. If this is not the operation of the member under section 397 and bringing material changes in the management under section 398, then what could be the better case than this? And then, my lord, the last paragraph, paragraph 49, liberty was given. Let a board meeting be convened within 21 days to all the directors by registered post at their NRI addresses in India as well as USA. The meeting shall be chaired by Dr. Kamal Kumar Datto, Managing Director. In case any of the NRI director is unable to attend the meeting, he will have a right to make nomination. We again make it clear that all the resolutions are set aside with regard to raising of funds dated 19th April 95, removal of Dr. Binod Prasad Sinha from the Board of Directors, outstripping of Dr. Kamal Kumar Datto from the Managing Directorship, allotment of shares to Sajol Datto's companies and to others, and all other resolutions which adversely affect Dr. Kamal Kumar Datto and Dr. Binod Prasad Sinha. Now, my lord, on this basis, my lord, on the basis of the order passed by the Honorable Supreme Court, the meeting was held on 16th of September 2006. My lord, if your lordships are pleased to take up, my lord, the second compilation. Second volume, kindly take up the second compilation, my lord. Kindly come to page 367. My lord, two portions I would show, my lord. Kindly come to page 367. Kindly come to page 374. (374), my lord, the last paragraph. Board considered the issue raised by Mr. Sajol Datto. Dr. Binod Sinha clarified that equipment supplied by Dr. Kamal Datto are in operation even as on date. Well, this was in 2006. For about 13-14 years, my lord, the machines, or 12-13 years, the machines were operating. And then, my lord, kindly come to the next page, my lord. The decisions, two decisions were taken. One was to withdraw from the writ petition. And the second one was, my lord, to issue shares, my lord, to Dr. Kamal Kumar Datto. Yes. Now, the Sajol, my lord, had challenged the second decision regarding issuance by filing, my lord, another application before CLB, my lord, which was dismissed. I have placed that order. So far as the first decision is concerned, my lord, or the other decision to withdraw from the writ petition, that was never challenged. Now, my lord, today, my lord, if your lordships are pleased to look into the cause title once, lordships will find, my lord, lordships are aware that, my lord, the company is not a party to the appeal or in the writ petition. So, my lord, any order passed here, my lord, in my respectful submission, my lord, any order as prayed for in the, my lord, writ petition, my lord, would be an infructuous order because the company is nowhere there. The order will not be binding on the company. And the permission was granted to the company.
Yes.
Now, my lord, if your lordships are pleased to look into, my lord, I have placed this order. I really do not want to repeat. The first page of, my lord, the second volume, page 225, my lord, the order of Justice Ray. My lord, lordships can take it from me, my lord. The order does not, my lord, speak about any personal right of schedule. Justice Ray was not concerned with any personal right of schedule, only, my lord, the Reserve Bank's permission under, my lord, the two sections of, my lord, the page 225.
Yes.
Naturally, my lord, when Reserve Bank of India, my lord, has passed the order impugned at page 257, my lord, I have again checked the order, my lord. The order does not, my lord, refer to any personal right of schedule, my lord, which, my lord, the learned single judge had, my lord, proceed on the basis of which, my lord, the learned single judge had proceeded. And, my lord, again, my lord, the writ petition also does not contain, my lord, any averment.
Yes. Yes.
The writ petition also, my lord, I do not want to, my lord, show it again, my lord. I have shown your lordships. The writ petition, my lord, does not agitate any personal right of schedule. It only speaks about, my lord, the permission. It does not say how the permission can affect the right of schedule. Now, my lord, the application was made at a time, my lord, the two sections of the Foreign Exchange Regulation Act. At a time when, my lord, the question was the foreign exchange going out of the country. Here, my lord, in this case, no foreign exchange, my lord, was required to be drained out. He was purchasing the machinery. He purchased the machinery, my lord, in USA or, my lord, outside India, and had supplied it to India for being utilized in the hospital. That was all. And the permission I have shown your lordships the exim policy, the modified exim policy, which entitled, my lord, supply of, my lord, second-hand machinery on non-repatriation basis. Now, my lord, the exim policy was shown.
You are saying that the purchase was with foreign currency.
Yes. There was no question of, my lord, draining out of any fund out of the country. It's nobody's case, my lord, that foreign exchange went out of the country. It was purchased in USA, supplied to India. Now, my lord, exim policy I have shown, my lord. If your lordships are pleased to look into once, my lord, volume 18 of the paper book. Page 595, my lord, I had shown your lordships. May I read it out? Page 595, my lord. Kindly come at the bottom of page 595, paragraph 2. The specific issue raised in these cases are, kindly come to Roman 3, repatriability of such investment by NRI against direct payment of imported machinery, which are second-hand equipment.
You said these issues don't arise here.
No, here, my lord, permission was granted. Kindly come to the next page, 597. See, kindly come to, in all such cases where the amounts are paid directly by NRIs.
Yes, you had relied
Against
on
import of second-hand capital goods, the investment is permissible only on non-repatriable basis. That is
Yes.
exactly
We have marked it.
what has been done. And kindly look into, my lord, who has issued the direction at page 575, 595. It is issued by, my lord, one Mr. Puri, Director, FIFT.
What is FIFT?
My lord, this is, my lord, foreign investment and foreign trade or something like that. The authority, my lord, under the Foreign Trade Development and Regulation Act, which I have placed before
So
you.
the competence of the authority is not an issue anyway.
I think it's a government of India.
This we have already seen this.
And my lord, so far as this, my lord, this permission is concerned, my lord, the RBI had no role to play. It was absolutely, my lord, if your lordships are pleased to look into the act, my lord, the Director General specified under that act was, my lord, the person who was authorized to take, my lord, all decisions. And if there was any contravention, my lord, there would have been penalty. Nothing has happened. And if, my lord, it is a second-hand machinery below the price, what the allegations which have been now sought to be made, my lord, those were, my lord, for the customs authorities to look into, my lord. The Reserve Bank, my lord, had nothing to do with all this. Customs clearance was granted, admittedly, they never raised any dispute. Yes, and that is recorded in the Supreme Court. Well, lord, those are my respectful submissions. হ্যাঁ বলো উত্তর দাও
So Bishop Mukherjee was looking for a date of 17th, 18th or 19th, Your Lordship, to reply.
17, 18 or 19?
Any
Strictly speaking, my lord, when I joined, unless, my lords, a new case was, my lord, or no, new law was, my lord, relied on in opposition, my lord, there was no reply. But that is no more there.
So which date? 18, 19 or 20th? Let's have it on 18th. 18th is I see.
Item number 8.
Your Lordship, I am appearing for the petitioner.
Yes,
Your Lordship.
you are the petitioner.
Your Lordship, I am for the petitioner.
So why it should not be granted, the relief granted by the tribunal?
Your Lordship, on the last occasion, I had shown that the uh, circular that we had issued a circular, the railway board had issued a circular stating that each case has to be decided on case to case basis, and it cannot be that and the application was made at a very belated stage.
That appears
And
to be the only ground you have asked before the tribunal.
Your Lordship.
So many people have no. Then hurry up. No? Yes, the Heard learned advocate for the writ petitioner and the
Item number 13.
Not find Mr. Mukherjee. I was trying to get him.
He has to make the submission. So we'll not today, just ask him to be here tomorrow, not passing any order. You are for the private petitioner in this case. No,
Item 14.
But I am appearing before the petitioner. My lord, the only point, my lord, in this writ petition, my lord, the petitioners, my lord, the appointed as a trackman. My lord, when the examination was held, then my lord, two posts, senior trackman, PY, and my lord, junior. But my lord, when selected, there was the post of junior. But my lord, when the date of appointment, before that, my lord, LOA board issued a order. When my lord, that both posts, my lord, the merged in one post. My lord, then the petitioner, after issuing that memorandum, my lord, petitioners giving appointment. Our contention is the petitioner is entitled to get, my lord, the post of the salary of the merger post. My lord, but the department, my lord, after giving, my lord, that salary after 2 years. My lord, this is the point, my lord, and earlier, my lord, this court, my lord, directed me to annex, my lord, the original application which was filed before the tribunal, my lord. This is the, my lord, a supplementary affidavit, my lord. This,
what is your date of appointment?
date of appointment, my lord, 26th April 2007. 2007. merger of the postponement 22nd March 2007.
Yes.
But kindly go to page. But that merger of the post, my lord, on 22nd March 2007. Our appointment after that. Well, then there is no post on that cadre. My lord, in page 37, my lord, the railway authority specifically says state that the candidate who are appointed after introduction of a new recruitment grade of senior PWS in grade pay 4,200, that is all those appointed after issuing RB such and such were directly appointed in grade pay 4,200.
Yes.
They given, but after 2010, 2010, my appointment 2007. And also, in another division, Malda division, 2006, the selection process was started. They were selected. Then Malda division already given the benefit in respect of the employee of the Malda division's railway. Page 36, the 3-person appointed. Page 36, they are already giving the benefit.
When did you raise this claim for the first time?
After 2010, Malad. 2010,
after you were already placed in the higher, in the merged post.
What? Because Malad, merged post, March 2007, Malad, they giving appointment in April 2007.
That you have already said. You need not repeat that. You said in 2007 the post had been abolished. It has already merged in the senior supervisor post. Therefore, I should have been appointed directly in supervisor. That post is not in existence.
Okay.
But the fact is you were appointed on the post which was you say has been abolished.
Abolished as per
Fact is you were appointed on that post only. And after undergoing training for 2 years, you were put to the higher post in 2010. And when you got the higher post and higher scale, then you said, now you give it to me from 2007, because since 2007, there is no post. This is your case. And you are claiming parity with someone. You have implemented anyone as a party.
No. Because as per Malda division already giving. But in the Sialda division, we are employee in a Sialda division.
And where is the order abolishing the earlier post?
That's
Circular or order, what is it?
page 24.
It is of 22/3/2007.
But 22nd March 2000.
Yes. So both are group C.
Both are.
The earlier post and merged post, both are group C.
Only scale 4,500, 7,000 at 5,800, 5,000 to 8,000.
And prior to abolition, there was a requirement of 2 years
Yes, but that is we are in a direct category. Yes,
That you have already said, sir. That we have understood. You are saying after coming into force of the merger, we have been appointed. We are asking you prior to coming into force of the merger, there was a 2 year period was contemplated before you could be placed on the senior or whatever supervisor. That's all. Third Learned Council for the application.
Shiva, I am appearing for the petitioner in this matter. I have challenged before your lordships the tribunal's impugned judgment dated 26th August 2019, wherein and whereby the present petitioner's claim for pensionary benefit of her deceased husband has been denied, denying thereby her legal heirship of the deceased husband. Because of the reason, she is the second wife of the deceased. Joydash is the deceased husband. Snigdha Mondal, the lordship. Joydash, the deceased, was the husband of the present petitioner, Snigdha Dash Mondal. Initially, Snigdha Dash Mondal was married to one Ujjwal Shaha in the year 2009, 3rd July 2009. Immediately 1 year after the marriage, she left the matrimonial house and started to live in with the deceased Joy Dash. Thereafter, in the year 2014, one male child was born. And in the meantime, in the year 2012, matrimonial divorce suit has been filed by the earlier husband of the present petitioner. That was decreed in the year 2016, lordship. The date of decree is 2016, 7th April. After that, your lordship, in the year 2016, in the month of June, the present petitioner was married to the deceased Joy Dash. And the invitation card is annexed herein. Lordship, the earlier marriage was in the year 2009, 3rd July 2009. And the divorce suit, mat suit was filed in the year
2012.
Marriage was solemnized with the earlier husband in the year 2009 and with the deceased Joy Dash in the year 2016, 20th June. And divorce decree was obtained on 7th April 2016. Immediately after 2 months of divorce decree.
What is the date of your registration of your marriage with late Joy Das?
That is 2011, your lordship.
No, that is 2012, madam.
Lordship, I am not pressing that one.
30th March 2012.
Lordship, 11.
2012.
I've seen somewhere, right? That's why I was asking. 30th March.
That registration certificate, I am not relying on, your lordship. I am.
You have told the tribunal that this is the date of your.
No, your lordship, I have annexed. Kindly come, lordship. The invitation.
By not relying on it, it will not vanish.
Lordship, I'm showing your lordship. Kindly come to page 28.
So you were married. That is not in dispute. You were married. The marriage was after demise of the erstwhile wife, or earlier wife.
Earlier wife expired in the year 2007, lordship. 4th October 2007, first wife died.
And she left behind some children.
One female child, one
male and one female. And there is any child out of your wedlock?
Yes, your lordship.
Do you have any children?
I have one son, but he was born in the year 2014 when I was in living relationship with the deceased husband. That at that point of time, the Hindu marriage, customs marriage was not solemnized. That was performed in year 2016 after obtaining decree from the first marriage. Officially, the decree was obtained.
So you have made a representation for the grant of benefit of pension.
Family pension, yes, your lordship.
Where is that? Let us see. From that, it will be clear what is the basis of it. Page 35.
6th March 2019.
That is the decision of the CMOH, Your Lordship.
No. Where is your representation? This is the decision on your representation. We want to see what is your claim. You have, because you say till 2012.
Lordship, page 30. Page 30, Lordship. Annexure C.
Madam, how can I understand this?
Page 30, Lordship, my representation. And page 35 is the decision of the CMOH.
This is not for pension. I'm informed this is not for pension.
Lordship,
Page 30 is not for pensionary benefits.
that is the representation made to the VMA. But regarding the representation, Lordship, it is observed in CMOH order, that is at page 35, Your Lordship, annexed P8.
So what is mentioned in page
Kindly
30,
come.
second paragraph, last paragraph? What is mentioned there? Page 30, last paragraph.
লর্ডশিপ, আমার স্বামী জয়দাস পুরুলিয়া জেলার মানবাজার 2 নম্বর ব্লকের বাড়ি হেড অফিসের অন্তর্গত দিঘি প্রাইমারি স্বাস্থ্যকেন্দ্রে কর্মরত ছিলেন। কর্মরত অবস্থায় আমি আমার স্বামী ও পুত্র সহ দিঘির হসপিটাল কোয়ার্টারে বসবাস করতাম। 18/2/17 তারিখে পুরুলিয়ায় আসি। পুরুলিয়ার বাড়িতে তিনি অসুস্থ অবস্থায় মারা যান। আমার বিনীত অনুরোধ এই যে আমাদের সমস্ত যা জিনিসপত্র সেগুলো বাড়ি নিয়ে যেতে পারি এবং তাকে অনুমতি
Not for pension.
আমাকে বাধিত
Not for
করিবেন।
pension.
Not for pension. This is
Yeah,
for
for
articles.
For articles.
For the articles.
But Your Lordship, kindly come, just may I be permitted to go through the order passed by the CMOH, page 35, Lordship. There it is. As
We are reading, just let us read.
heard the opinion from both the party. It appears that Snigdha Das Mondal claimed all facilities for herself along with her son.
And what was Matt suit 143 for?
That suit for decree of divorce filed by the earlier husband of the present petitioner, Ujjwal Shaha.
Oh.
Second marriage.
So the person you married, he was married from before, and you were also married from before.
I was married and the person was also married, but the deceased first wife died
But
in the year
your marriage
2007.
with the earlier husband was dissolved in 2016.
Earlier husband was, marriage was in the year 3rd July 2009. Thereafter, he filed mat suit in the year 2012. And the decree of divorce obtained on 7th April 2016.
Correct. So till 16, you were married with the earlier man.
And I have married, customs marriage was performed on 20th June 2016, after 2 months from the date of obtaining the decree
We
of
don't know.
divorce.
You say you give 3 dates, madam.
Yes, Your Lordship.
You are married with the deceased on 11/11/2011.
Yeah.
Then you say as per Hindu rights and customs in 2009. Now you are saying after 2016. So which is the date to be taken?
2009 was the earlier marriage of the present petitioner. First marriage with another person.
What is his name? What was his name?
Ujjwal Shaha.
Ujjwal Shaha.
Ujjwal Shaha was the first husband.
So,
He
but then you,
filed mat suit.
but with this deceased also you give
This
2
is,
dates.
I have married on 20th June 2016. That invitation card of marriage I have annexed at page 28, my lord.
Where is the certificate of registration you have submitted before the authority? Which certificate of registration of marriage you have submitted?
So this certificate which I have annexed here,
Where is it?
page 23, your lordship. Page 23 and 28 is the customs marriage performed after obtaining decree of divorce.
So this is with the person whose pensionary benefits you are claiming.
Yes, your lordship.
And this is of 2011. So how can you be married when your divorce
In
has taken place?
2016, I have performed customs marriage, your lordship. The invitation card is also annexed, your lordship. Kindly come to the page 28, lordship. 20th June 2016, Brihaspatibar, Preeti Bhoj. This is the card, your lordship.
Where is the custom marriage?
That is, your lordship. I have annexed in 2018.
Where is it? Which page?
Page 28. Invitation.
So one is certificate marriage and the other is custom marriage.
Lordship, that registration certificate I am not placing, your lordship.
How that can be?
It will not ban. You have placed it before the authority.
After obtaining decree of divorce, I have
So this is nothing but a card. An
invitation card of the marriage, your lordship. And we have a son born in the year 2014. And the first wife of the deceased died in the year 2007, lordship.
That you have already said, but then if you are granted any benefit, it will be out of the dues which are otherwise to be paid to his son and daughter. So for such a person, whether it should be done or not, that is the point.
But at the person died.
So what is your submission? What is the infirmity in the tribunal's order?
The person died on 2nd March 2017 when the petitioner was married to the deceased, your lordship. In the year 2017, 2nd March, the death
A wedding
occurred
card,
of Joy
wedding
Das.
card cannot be taken as a proof of marriage. The certificate you have submitted cannot be ignored. And how
Wedding
that
photos are also there, your lordship. I have not annexed here.
Marriage certificate. Marriage certificate is valid because of 2006. Supreme Court already has said that all the marriage relates to a caste and creed must be there. 2006, Supreme Court said in respect of caste and creed, every marriage must be registered.
That means
that would be valid document.
social marriage cannot be denied.
No. Social marriage. Can you see the language?
Saptapadi and
this 30th March 2012 and
all the rituals
this have been recognized because has been Hindu marriage has been solemnized in accordance with the customary rites and ceremonies in terms of section 5 and 7 of the Hindu Marriage Act 1956 on 11 November 2011. It's a census between them, and at that time they have been living together as husband and wife.
But when
husband
the
was alive.
person died in the year 2017,
The point
the
is
petitioner
whether
was the married wife.
the only issue is that she has produced a certificate when she was still married to the earlier person. So how that can be? But then she says she has a son. That is what is.
No, the first wife, when she got the second wife, he has got a husband. That marriage is void.
And in the year 2016, when
That son was born in
2014, when the petitioner was in live-in relationship with the deceased, Joy Das.
Too much of a disputed claim. It cannot be. We cannot deal with this issue here.
But your lordship, kindly consider at the
Parentage
time
of that person who has been born also, that
But
will be required to be seen, because at that time you
of
are claiming two dates. One is based on a certificate issued in 12, other is based on a card issued in 2018. 16. The son is born in 14. For the purpose of the son, you want to rely on the live-in relationship, and for the purpose of pension, you want to rely on the card.
For the purpose of the son, lordship, it is fact that the son is of the Joy Das, deceased
Sorry,
Joy Das.
we are-
And your lordship, the at
You
the
may,
time,
if you want, we can give you liberty to avail civil remedies in
lordship,
accordance
at
with.
the time of death of the deceased, the petitioner was the married wife of the deceased,
All
your
right.
lordship. In the year 2016, already
My Lordship, I'm appearing for the petitioner side, My Lordship. Senior Advocate Vikashan Bhattacharya. He is engaging in right now in Supreme Court, My Lordship. So kindly, My Lordship, take this matter after the vacation, My Lordship.
Mr. So and so, give your appearance, appearing on.
Item 17.
My lord, I am appearing for item number 17. I am appearing on behalf of India. And
Yes, you are to give us the status regarding the other claims.
my lord, am I audible? My lord, am I audible? My lord, your voice is cracking a bit, so I couldn't hear you properly. Learned ASG is busy on some other matter, so I would kindly request my lord to kindly post it for tomorrow, 2 p.m.
No, you are required to come with some instructions. What is the instruction?
My lord, as of
Regarding the claims of the legal heir of the deceased employee.
yes, my lord.
Oh. Let him come tomorrow, not
Let
today.
it be after vacation. No, not now. After vacation.
All right.
All right, my lord.
Lordship, the learned ASG has prayed for time. He wants the matter. He's asking for the matter to be fixed tomorrow, Your Lordship.
Cannot be heard learned counsel for the learned counsel.
Seventeen.
এসছে কি বই? My lord, on the earlier date, my lord, your lordship pleasure was to file paper book. So we have submitted it in the department.
You have given him a copy?
Yes. Yes, we have given him a copy. পেপার বুকটা দিন দিয়েছেন?
There is any interim order?
No, there is no interim order. We have come before your lordship, my lord,
challenging the order passed by the learned tribunal, and the order passed by the honorable tribunal.
Yes. Yes, I am appearing.
73 to 89 of the paper book, volume 1.
Not right. That's not.
আসেনি হ্যাঁ
We have 5 pages. ঠিক আছে। The book has to be reviewed.
আচ্ছা ক্লার্ককে আপনি না ঠিক আজকে মামলাটা হয়ে যেত চারটে না Yes, we are informed that
হবে। My Lordship, I have one request to submit before you.
Yes, please.
I am stationed at Chitranjan, which is almost 230 kilometers from here, and High Court's list is published at 9 p.m. By that time, reservation list is already clear, so I don't find reservation. So, if it be possible, can we give a date, a fixed time, maybe tomorrow or day after tomorrow? Day after tomorrow.
Not day after tomorrow. I have some here. Tomorrow it can be done.
Yes,
We have fixed it on 15th.
15th.
Yes. 15th is a Monday.
Okay. Thank you, my lord.
Item 19.
Matter I am appearing on the respondents.
I have got the petitioner, my lord. My lord, on the death of the petitioner, my lord, your lordship allowed me to file substitutional application. My lord, I have filed that file.
Substitution.
But substitution application has not been solved. It is to be solved, my lord, before the my lord authority.
Then what?
Can number?
1 and 1 to 525.
Can. Files are not complete. When it is appearing on the list, you don't look for it until the case is called. You don't check beforehand. So when I ask you, then only you will get it. What is the system?
But it will be given to the authority concerned. Then through MOL, it will be handed over to me.
Only substitution.
But substitution is for it is her formal normal practice to submit before the authority concerned. Then it will be. আর আমাকে দিলে আমাকে তো আবার পাঠাতে হবে।
August. 12th August. 12th August. Petitioner, my lord.
Petitioner. The sole petitioner. And how many legal heirs? Where is the details? Huh?
What is this in page number 8? Annexure, Annexure A.
Residential certificate issued by the Pradhan.
Where is the death certificate?
Yes.
Where is the death certificate?
Next page, my lord.
It's not the death certificate.
Panchayat Pradhan. That
Whether we will consider the certificate issued by the Gram Panchayat Pradhan? No, not at all. Not at all.
I file that, my lord, after collectors.
This is a legal year certificate, not death certificate.
These Panchayat Pradhans issue sometimes
At that time, it
the
was
same
not-
person will be alive some years later.
Allow me to file supplementary affidavit, my lord, I file.
What will you do?
File supplementary affidavit, my lord, after getting this. Kindly allow me.
The advocate for
Seven 20.
Intento. Resolution. So it's expression data. Resolution. Now, first there's a hurdle of restoration. The matter was dismissed, and she will find an application over there, which is 1 of 2023. She found application, yes, which speaks of the default or the dismissal due to non-absence of the advocate concern. Service. এটাই তো আরেকটা আমাদের তাই না
To be honest, this is once again I'm before your lordship before with regard to the matters being pending before the tribunal. On regular occasions, kindly have a look. This is a matter with regard to compassion appointment. The way the things are being done, and if it's being regularly not being taken up and accommodations are being granted, the lordship knows time goes, compassionate goes. What I was beseeching before the court at this present juncture, the lordship may direct the tribunal to decide the issue within a specific time. That will suffice my purpose. Because unnecessarily things, if your lordship be with me on the order itself, lordship will find there's a impugned order which speaks, thus 2018, that yes, on page 22, it will reveal. Initially, there was an order that is on page. That is on page 18, which reveals that you are not fit enough to be on a particular post of constable, though you can apply for Group D. Be that as it may, subsequently they themselves say that on page 22, any of the eligible dependent member will be allowed. There are two contrary orders to that effect. First, if your lordship be with me on page 80. As was found, is not adequate for the post of constable. And subsequently,
No, we are not entering the merits of
yes,
the matter.
lordship, I know what's falling for. Kindly, they are them to decide within a month or some whatever you.
No time frame can be fixed.
Until unless.
Yes, take
I've
down.
already faced a difficulty, and I am before your lordship with
The petitioner.
And, for a moment, your lordship, kindly be with me. Was one of the orders being passed by this court. That's a time frame order. In fact, even then I am in a difficulty. Be that as it may to judge. Only one. Act a copy. Sorry, Mal. Another copy is there. This. এটা আছে এতে না না এটা না এটা না same difficulty we faced 30 times matter appeared, we came before this court, got the order. Even today I am hitting this court once again. Be that as it may, this is for the first time with this matter. But you will find there's a time frame to that effect. This is my sole prayer.
There is no watertight time frame.
I should find within 1 month.
Please read if you have a copy.
একটা দিলেই হবে
Give him one and give us one.
Yes, we expect the single member shall take up the instant matter on the date so fixed, and endeavor shall be shown to bring the litigation to a logical within 1 month. Therefore.
Endeavor shall be shown. That's why we said there is no time frame.
Only
there cannot be. Therefore, we wanted to see whether there can be such an.
She kindly make a
heard learned advocate for the It is an endeavor means only an attempt. So it can be said in many ways. We have said to proceed expeditiously. You know, the apex court has passed a judgment. We are not supposed to circumscribe a time limit.
In fact, to be honest, with the other matter which has just placed, this was the issue. And I am once again before Lordship with this decision. Even then, nothing has been happened. I mean, it's becoming an absolutely unending aspect. We are coming, visiting the doors, knocking the doors, granted with the accommodation, went back.
But 2019.
Pathetic.
In 2020.
Justice Tandon's order was there. In fact, my learned senior friend was there to get the other members to be in, to get other members engaged over there. Nothing. It's only a showcase, to be honest. Nothing is being done. Sometimes the administrative member, to be honest, is not that much courageous enough to decide the issues. My personal matter, I am facing the difficulty. He says there is a very big issue. I am not in a position to decide. No judicial member is there. Absolutely horrible issue. Absolutely horrible. This is absolutely coming to a natural death every day. If these ways things are being done, automatically persons are being superannuated. They are leaving the mortal world. We are becoming helpless regularly. I know what's falling from Lordship's mind, but we are also answerable somewhere. Even in fact, it was in 23 itself. Justice Tandon's order was there. In order to engage persons, there was a direction on the state government. So at least there should be vacancies being filled up forthwith, so that at least something is being done. Nothing is being done. So kindly have a look when this order was passed. 23. My learned senior was there on that matter, wherein there was a direction. Twitter was in the. Yes, in fact, that's prior to that, speech was still pending. And in fact, I'm knocking the doors once again before the Lordship few days back with this matter itself. So see, the Lordship has granted this order. Lordship has been over there before I could have the Chief Justice, but I am still over here doing nothing. We place the orders. No, I can't do anything. This is orders. Kindly see our plight this side. No, she was there this side, in fact. She knows. We are every day we are being unanswerable to the calls being made. What I'm doing, at least there should be some answer. My Lordship, thrash out my matter, no issue. But at least what I'm doing, there should be some answer. Whenever I go, accommodation is being done. Pathetic.
21.
কথা বলছি।
21, my lord, I am appealing for the petition.
In fact, I expressed my sordid state of affairs. Lordship is taking up the appeals over tribunals, but this is the situation. Then what would have been the situation? Kindly appreciate. Had it been full force. Grateful.
Lord, I am appealing for the petitioner. My lord, on the last occasion, there was a direction to file upon the respondents to file their affidavit in opposition. My lord, today I have been handed over the opposition. My lord, filing today.
Yes, my lord.
My lord, may I seek time to file reply to it, my lord? 2 weeks time, my lord.
My lord, actually, person was dismissed from service and his wife, my lord, claiming from pension from the railway. And matter is also the Raipur, my lord.
Let us come back.
Chief, I am appearing for the petitioner. I am praying for not today due to some personal emergency.
What do you want?
I'm appearing on behalf of my senior. She could not come today due to some personal emergency, Lordship.
I'm for the respondent, my lord.
I'm praying for not today.
Not today.
Seven 23.
Okay, my lord, I am for the petitioner. The second round of litigation regarding compassionate appointment. Petitioner's father was roller driver under the PWD. Petitioner's father.
Roller driver.
Roller driver. Initially, my lord, the application was turned down on the ground, my lord, that
Date of demise?
2011, 11/2/2011.
Yes.
Now, my lord, in 2018, the application was considered for the first time. And it was turned down on the ground that
Date?
3/5/2018.
Yes.
It was turned down on the ground that his father was not an employee of the regular establishment within the government. My lord, application was preferred before the learned administrative tribunal, where, my lord, the order was set aside and it was remanded for
OA number?
Lordship, OA number 40 of 2019. Lord, the operative portion, I am reading it out. The order under challenge cannot be sustained and is thus set aside and quashed. The application is allowed. Accordingly, the Secretary, Department of Public Works, Navanno, Howrah, the respondent number 2I is directed to consider the matter afresh for appointing the applicant on compassionate ground by passing a reasoned order to be communicated to the parties within. Now, my lord, thereafter, it was considered and an order was passed, my lord, in 2022. My lord, now, my lord, it was held that he doesn't fulfill the eligibility criteria regarding the age. My lord, his age by that time is now, my lord, 45 years.
Where is the order? Which page?
Lordship. It is, my lord, the page, it starts from page 37. The conclusive part, my lord, is page 42. On two grounds, my lord, it was rejected by the authorities that educational qualification, my lord, the applicant did not fulfill the criteria of educational qualification and maximum age limit as per extant rules. Since he is class 6 pass and his present age is more than 45. When he applied, my lord, he was 38. 35. Now, my lord, this order was again challenged before the tribunal in OA 28 of 2023. And against the order dated 10th of August 2023, my lord, this writ petition. My lord, the learned tribunal, my lord, held that although there is a provision for relaxation of the age as well as, my lord, minimum educational qualification, but since the representation was, there was no such representation praying for such relaxation, it cannot be allowed. My lord, when I applied for the compassionate appointment, my lord, there was no scope for praying for relaxation of the age. And secondly, my lord, for an application for compassionate appointment, there is no prescribed format for praying for relaxation or for, my lord, any concession. My lord, it is exclusively within the domain of the respondent authorities. But, my lord, kindly seize the order impugned. My lord, may I place, my lord, the operative portion? Though there is a provision for relaxation of both educational qualification and maximum age of appointment, however, such representations were never preferred by the applicant before the respondents. Cited by the respondent in the recent order, point 7 of West Bengal Services Group D Recruitment Rules 2009 is a proviso by which the upper age limit can be relaxed by 5 years for candidates belonging to scheduled castes candidates. The applicant belongs to the scheduled caste category. However, no such representation was filed before the concerned authority for such relaxation. Similarly, the educational qualification required for such employment could have been relaxed if such representation was furnished. However, as admitted by Mrs. Rai, no such representation was furnished by the applicant. In view of the above facts, the tribunal finds the respondent was correct in regretting this appointment. My lord, aggrieved by this order, my lord, I have come up before your lordships. My lord, there is, my lord, the rules or whatever, my lord, scheme is there, my lord, there is no such, my lord, mandatory provisions for the candidate to pray for this concession or relaxation, which could be considered. My lord, I prayed for compassionate appointment, which is an exempted category appointment. And my lord, it is for the authorities, my lord, to decide. And when I applied for in 2011, at that time I was not underaged also. It was first considered in 2018, and it is not rejected on any other grounds. This is my humble submission before your lordship.
You know that it has been rejected on 2 grounds, and you are saying only on the age ground.
Age and educational qualification.
So that you are not, you are saying there is no other ground. How you are saying there is no other ground?
No, 2 grounds.
You are not having the requisite educational qualification.
My lord, that is, my lord, the authorities have the, my lord, the power to relax it. In
So
fit
therefore,
case.
in every case where a application is made by an overage person or underqualified, what the authority is required to do under the policy, let us see.
No, the economic, the condition is
what
to
does see the law of compassionate appointment is very settled.
Lordship.
It is in exception to the rule.
Lordship.
Therefore, it has to be strictly in accordance with the provisions containing the policy. So where the policy says that wherever an application is made by overage person or underqualified, the authority has to go for relaxation.
No,
where does it say?
I'm not asking for that.
That's precisely what you are saying,
But
that I am not required to apply. They should have considered.
Well,
so unless there is a requirement under the scheme that whether you apply or not, they have to consider. How can you make such a submission? So show us the scheme where it says.
Well, the scheme, but I do not have this scheme with me, my lord. Well, what I am on, my lord, kindly.
This is what you have argued.
Well, may I clarify myself? May I clarify myself? My lord, the compassionate appointment, my lord, the sole criteria is the first and foremost thing which has to be looked into is whether, my lord, the financial condition. Now, if it is a beneficial legislation, my lord, to tide over the immediate crisis. Now,
if we are on whether you are required to make an application or not.
I made an application that they have not denied.
You made an application for exemption.
No, exemption. I prayed for.
You know the issue is only that.
Yes,
There is no point. There is no point beating around the bush.
My application.
The point is whether you are required to seek an exemption from the upper age qualification or the educational qualification. Now, what is your submission? You are not required to apply for anything, and they should consider on their own.
My submission is I have applied for compassionate appointment.
We are not concerned. That's not relevant. You know the relevant issue is whether you have applied for an exemption or not.
My lord, that is what they have said, my lord. My submission.
That you know, that is an admitted position. You have not applied for exemption.
I have not, my lord, when the application was made, but on the 2 points, overage.
The point is whether without applying for exemption, you are to be considered or not. Show us from the scheme. that whether you apply or you don't apply, they have to consider. Show us.
On that issue, my lord, may I then come back, my lord?
No,
Because
what come back? It is all right here. All
No,
the
but
schemes are here.
why I am saying so, my lord? The application, my lord, there is no prescribed format for the application.
How many times you will say that, sir?
So, my lord, then, my lord,
Point is whether
I shall try to satisfy your
not
lordship.
try
on
to.
those-
We are
on those issues,
having
my
all
lord.
the schemes right here. What
I
is
was
that?
of this impression, my lord. I was of this, my lord. I may be wrong, my lord. But my lord, I can come back with I can satisfy your
Let us see
lordship on
right
that
now.
issue.
Let us see right now.
The scheme says, my lord, there is a provision for relaxation.
Yes, where
It
is
doesn't
that?
say that
Where
I
is
have-
that relaxation provision? You tell us.
$2,900.
251 EMP.
251.
My lord, in this my lord, Labor Department's notification of 2013, in my lord 251 EMP, there, my lord, on these my lord, clause 6, my lord, regarding eligibility, at note A, says that condonation of excess in age in case of eligible cases will be made by the respective head of the department or their subordinate officer who are competent to make the compassionate appointment as per existing provision. He says relaxation in educational qualification may be granted in eligible cases for appointment to Group D post in consultation with the finance department. So, my lord, the first thing is, my lord, that if the case is eligible, then they have the power to relax. If the case is not eligible at all, my lord, this notification, my lord, I have a copy. No, my lord, the for consideration of the eligibility of the candidate, clause 6 says, my lord, the family is indigent and deserves immediate assistance for relief from financial destitution. For this, any of the following two conditions is to be satisfied. Then, my lord, those monthly income of the family, all these things are there.
You filed an opposition before the tribunal. Reply.
No, only with this reason order that was considered.
No,
There was
reason not.
no opposition was not
Only at
filed.
the admission stage it is when this put.
File a reply. File opposition. Yes, let opposition, affidavit in opposition be filed.
I appear for the respondent, your lordship. तुम्हारा हैंडराइटिंग समझेगा नहीं. Your Lordship, this matter will take some time. The matter may be taken up tomorrow, Your Lordship. The learned ASG was leading me, Your Lordship.
Tomorrow, tomorrow. In starting today, yes. Tomorrow, not today.
কালকে not to attend করিয়ে দেবো।
Not to attend.
ইচ্ছে লাল বলছে কি করে not to attend হয়, কাজই করতে দেবো না, চলবে না, হলবে না।
Should we have it tomorrow or should we keep it sometime later? Tomorrow.
Tomorrow, Your Lordship.
125.
I appear for the respondent led by Ms. Anamika Pandey. She's online, Your Lordship.
What is the issue?
Relation to the appointment of the collector and accountability will affect the 1997 process of copy.
জানি নাম দিয়ে দাও।
Selection process was supplemented calculated without right of this. Number of the question. Now we coordinate in order. Thereafter, the dependency of the original application to the tribunal, whether the authority proceeding to the tribunal granted us liberty to take part in the next election process. Ultimately, we lost in the original application. We came before the doctors. On 29 January 2014, High Court had passed an order granting the appointment figure, and such appointment would be guided by the old recruitment rules. Now, Miller, after that, we made an application that after March 2014, we were appointed. Our appointment conditions are guided by the old recruitment rules, which covers the old pension scheme. Now, Miller, we made a representation to the authority that kindly give us the national pensionary benefit, not the areas or the period where we had not fought. Now, when this application was rejected, I approached the Honorable Tribunal. Honorable Tribunal did not accede to our request and rejected. Now, during the pendency of the proceeding, the old pension scheme was introduced and we were covered by that. And we made the submission that suddenly, during the pendency of this writ petition, the authority said, no, the benefit that had been conferred upon you by way of a notification cannot be given to you. Now, your Lordship was kind enough to put a certain question to the railway authority that why did you do so? The moment the benefit has been conferred, and why did you put us to such disadvantageous condition? Now, Miller, the authority did not answer, but the only response made by the Railway Recruitment Board, the papers in this proceeding were not that it requires to the paper book was required to be filed. We filed it. Now, Miller, the railway authority is to answer that whether our claim is justified. On the one hand, the recruitment proceeding was guided by the old rules. Pension scheme was made applicable to us, and suddenly, Miller, the authority turned around, and whether, Miller, this is justified, whether this executive instruction, Miller, can curtail, Miller, the accrued right, and Miller, what is the basis thereof? The journey of the executive authority, Miller, or the executive action, Miller, does not predict any definite route or a thinking process. Mr. Shukumar Chakraborty, learned senior friend, Dr. Chaji, Miller is opposing, and Miller led by possibly
Anamika.
Anamika.
ASG আছে, ASG
is also there.
Yes, he's also there.
ASG also there. So his gracious presence, Miller, I hope, Miller.
2 minute কি করে gracious presence?
No, not today. We had asked them to come with the reasons. Yes.
Your Lordship, there are two issues in this. My learned friends' clients are asking benefits from 1999 when they had applied for the service, not from when they were appointed. That question has to be decided with regard to the new scheme wherein they were given an opportunity to be applied under the old scheme that has a cutoff date. Whether my learned friends had applied under that cutoff date or not, that's a question to be answered by my learned friend. Only then those schemes would be applicable. During the pendency of they are trying to mingle both issues. Whether at all when they did not work, their appointment was made by Honorable High Court by a order wherein by a mercy, more particularly, there was no such even a single line in the order that there was any negligence on the part of the
That
railway
we will
authority.
come to later. The first thing is you had consciously granted them the benefits under the old pension scheme. Why did you withdraw it? That we
No,
wanted.
we did not withdraw, Your Lordship. That scheme was applicable to all of our railway employees, including petitioners. But under that scheme, they had to give a letter. There was a cutoff date of October, such date, wherein they had to give an application. They want to adopt that scheme.
What is the cutoff date?
Your Lordship, the cutoff date is in the scheme itself. Your
Your
Lordship,
Lordship, in a similar matter, had heard where I had argued, I had placed all the notifications of the railway board, the cutoff dates, around 12 opportunities were given for those cutoff dates.
No, that's not the case here. Here the case is
Your
different.
Lordship, the cutoff date was 31st of August 2023.
So that is during pendency of these proceedings.
Your Lordship, that scheme is applicable to all my employees, not only
That is
particularly
during pendency of these proceedings. Perhaps that is why you issued the order.
Yes.
And why did you withdraw it? How can you insist that they must apply when they are pending, their claim is pending before the High Court?
Your Lordship, their claim is pending, particularly whether they want it from 99. We are giving it from
That is another
2014.
thing. Whatever is due to them, that you should have given them. Whether they'll get from 99 or not, that we'll decide.
Your Lordship, we don't have instructions or paper on record to show whether they had applied under that scheme.
That is precisely what we had asked you to tell us.
Not on record, then why should we see submissions? Highest court
By a supplementary affidavit, my learned friend, Your Lordship, had given them the liberty to answer what is the prayer they are asking as on this date.
Milord, I respect her, Milord, memory, but the question that was put forth, Milord, by the honorable bench was this, that what is the claim I am now, Milord, waiving?
Yes.
Milord, that is the
We
specific
remember.
query. Milord, her conscious misunderstanding, Milord, possibly next step.
We also remember. We had asked that what is the specific claim and what you are being deprived of.
Absolutely.
But then the deprivation increased because we were told that even the pension which has been sanctioned has now been taken away.
No, Your Lordship, there was a certain benefit.
Few minutes ago, she said that I should have applied within a time. I did not apply.
I did not say it. I did not apply. I am saying we don't have any document on record to show whether they applied or not.
Tomorrow, Milord, I will make appropriate.
Your Lordship, we will come back tomorrow.